New Mexico Oil and Gas Association, Wild Earth Guardians, Sierra Club Rio Grande Chapter, and the New Energy Economy. Copies of the proposed amendments to the rule have been and continue to be available on the division's website in the Rules tab. The hearing will be conducted in a fair and impartial manner, so as to assure that the relevant facts are fully elicited and to provide a reasonable opportunity for all persons to be heard without making the hearing unreasonably lengthy or cumbersome, or burdening the record with unnecessary repetition. Rules of civil procedure and evidence shall not apply to this hearing. As hearing officer, I will make such orders as may be necessary to preserve decorum and to protect the orderly hearing process. Hearing shall proceed as follows. Commission counsel will present pre-filed exhibits. Copies of exhibits admitted into evidence are available for review by the public in the case file on OCD's website. Any testimony provided by the identified parties will be taken under oath. As hearing officer, I will admit any relevant evidence unless I determine that the evidence is incompetent or unduly repetitious. Pursuant to the procedural order and notice in this matter, any person offering an exhibit should have provided the exhibit to the commission clerk prior to the hearing. Any exhibits not submitted prior to the hearing may be admitted at the discretion of the chair and only if it is possible for the commissioners and the participating parties to view the proposed exhibit during the relevant testimony and comment. Once we begin the formal hearing portion of this hearing, any of the identified parties that wish to make a brief opening statement before their presentation of direct testimony may do so. Immediately following opening statements, we will allow for public comments. Pursuant to the notice and procedural order, any individual that wishes to present public comments or non-technical testimony regarding the proposed rule changes should have notified the commission clerk prior to this hearing. The chair will call for public comment based on the list compiled by the commission clerk from the requests that were received. Public comment will be limited to 5 minutes each. There has been some indication that members of the public misunderstood the public comment process, including the need to provide prior requests. For this reason, and to ensure the full public participation is permitted, the commission clerk will continue to take email requests for public comment until 3 p.m. today. Those that make requests prior to that time will be permitted to provide public comment at the start of the meeting tomorrow morning. We will discontinue the technical testimony portion if it continues through today and recommence after public comment concludes tomorrow. Should the technical testimony end today, we will recess the hearing for the day and conclude with public comment tomorrow morning. If you are unable to remain on the meeting this morning to make public comment when you are called, we will recall you tomorrow morning to provide your comment. After initial public comments conclude, the division will be permitted to present direct testimony on the rule amendments. Other parties that have filed a timely pre-hearing statement with the intent to call witnesses will present their witnesses' direct testimony in the order I established. Pursuant to the procedural order, all technical witnesses should have provided written technical testimony to the commission prior to this hearing. The commission asks that testimony provided today not repeat the written testimony, but should supplement the testimony while providing necessary context to the commission. Cross-examination may include questions regarding both the written and oral testimony. Because this hearing is being transcribed, all persons presenting testimony must speak clearly at all times prior to providing testimony. Please introduce yourself and state your affiliation. Please remember that only one person may speak at a time. For all those persons testifying, please direct your testimony and answers to questions to the commission members. Any person who testifies or provides public comment is subject to cross-examination on the subject matter of his testimony or public comment, as well as matters affecting his credibility. Cross-examination by the identified parties will be conducted at the conclusion of each presentation, following cross-examined by the Commission and Commission Counsel. Parties that have filed a pre-hearing statement are entitled to conduct cross-examination of any witness. As hearing officer, I may limit cross-examination to avoid harassment, intimidation, needless expenditure of time, or undue repetition. After all technical testimony has been provided, parties that have filed a pre-hearing statement may present necessary rebuttal witnesses and then may make a brief closing argument in the same order as the direct testimony. We will now proceed. Does the Commission Counsel have any pre-filed exhibits to admit to the record?
Madam Chair, the Commission was presented with several pre-marked exhibits. I'm going to go through them in order, and I will take each party's pre-hearing statement and exhibits in kind, and then all the written statements together. Starting with Exhibit number 1, Commission Certificate of Compliance with notice requirements, and with the following exhibits: the legal notice published in the New Mexico Register on June 9, 2020. That's Exhibit 1A. 1B, the legal notice published in the Albuquerque Journal on May 29th and May 30th, 2020. 1C, notice of rules hearing posted on board's website on May 26th, 2020. 1D, notice of rules hearing posted on the Sunshine portal. And 1E, OCD notice sent to Small Business Regulatory Advisory Commission. Madam Chair, I don't believe we've had appearances from the identified parties. We may want to do that before we.
Sorry, can you repeat that?
We probably should hear appearances from all the identified parties that you mentioned earlier on.
Okay.
So do you want to request appearances from? Yeah.
We would like to request appearances from everybody who has filed pre-hearing statements. The OCD, the New Mexico Oil Conservation,
Excuse me, can you hear me? Can you guys speak louder into your microphone?
Does the OCD wish to enter appearances?
Yes, this is Cheryl Beta with the Energy, Minerals, and Natural Resources Department for the Oil Conservation Division.
Thank you. Does the New Mexico Oil and Gas Association wish to enter an appearance?
Madam Chair, members of the Commission, this is Michael Felderwart with the Santa Fe Office of Holland and Hart, appearing on behalf of the New Mexico Oil and Gas Association.
Does Wild Earth Guardians wish to enter an appearance?
Ooh.
Yes, Madam Chair. This is Daniel Timmons on behalf of Wild Earth Guardians, here today with my co-counsel Samantha Rescavage-Bars.
Thank you. I will also remind people that we need to speak one at a time, and we need to hold an orderly hearing today, and we will take actions if need be to ensure that we can have an orderly hearing. Sierra Club, Rio Grande chapter, do you wish to enter an appearance?
Yes, Madam Chair, members of the Commission, my name is Douglas Mickeljohn. I'm a lawyer with the New Mexico Environmental Law Center, and I'm here with my co-counsel, Kara Lynch.
Thank you. New Energy Economy, do you wish to enter an appearance today?
Yes, good morning. My name is Marielle Nanasi. I'm the Executive Director of New Energy Economy and an attorney. Is it possible, I didn't hear who is going to present on behalf of the Conservation Division, Well Conservation Division. Could that person or you please restate her name? Thank you.
The person presenting on behalf of the Oil Conservation Division is Cheryl Beta. Okay, Commission Council.
Thank you, Madam Chair. I apologize for missing that portion. I first asked that Exhibit 1, A through E, be admitted into the record.
So admitted. Are there any objections from any of the parties?
I'm sorry. Yeah, I would object just because we could not hear what exhibits were being admitted.
Okay, I will restate. Can you hear me now, sir?
Yes, thank you.
Okay. Exhibit 1, Commission Certificate of Compliance with Notice Requirements with the following exhibits. 1A, the legal notice published in the New Mexico Register on June 9, 2020. 1B, the legal notice published in the Albuquerque Journal on May 29th and 30th, 2020. 1C, notice of rule hearing posted on board website on May 26, 2020. 1D, notice of rules hearing posted on the Sunshine Portal. 1E, OCD notice to Small Business Regulatory Advisory Commission. And I would note that all of these are in the case file, not necessarily in this order, but they are located generally in this order in the case file on the OCD website. So again, I'll request that Exhibit 1, A through E be admitted, Madam Chair.
Are there any objections to entering exhibits 1A through E into the record?
This is Marielle Nanasi from New Energy Economy. I don't necessarily have any objections to this, but it's very difficult to, one, hear what you're saying. Two, how come we don't have these exhibits like posted right here so that we can see what you're referring to? Because it's very difficult to see them and just to say, oh, they're on the OCD website. We're focused right now on the rather than seeing these documents as part of this hearing.
Miguel, would it help for you when you're speaking? So all of the exhibits are, if you search the case number, which is case number 21281 under case files on the hearings tab of OCD's website. We are looking to see if we can find a better way. So bear with us for a moment.
Is there not a screen share kind of tool on this app or this WebEx thing?
Yes, there is. That's what we're attempting to do.
anybody who takes over the presentation and attempts to put their own information up on here will be removed if it happens a second time. This will count as your warning. If it happens again, we will remove you. And this goes for anybody who is doing any sort of action like that. We are trying to work through sharing this screen. As we said at the beginning of this meeting, we will work through things as they arise, so please bear with us.
Excuse me, while you're working this through, I wanted to ask you a procedural question, if I may. This is Marianne Lanassi from New Energy Economy. Can I do that, Madam Chair?
Go ahead.
What I wanted to ask you is the order that you're setting forth today that there will be opening statements, then public comment, and then Ms. Bada is going to present for OCD. Is that the way it will work?
Yeah, correct. So yes, opening statements, and then public comment, and then it will be in the order of the Oil Conservation Division, the New Mexico Oil and Gas Association, Wild Earth Guardians, Sierra Club, and New Energy Economy.
Thank you. And for instance, I understand that Sierra Club is giving testimony. When does that happen?
That will happen after the OCD and NMOGA and Wild Earth Guardians. Oh, my apologies. It will happen directly after the Oil Conservation Division presents their testimony.
When does one last question, I'm sorry, but when does the testimony happen? Does it happen after opening statement or after public comment?
After public comment.
Thank you.
No problem. Okay, so it looks like we've been able to screen share some of the exhibits. This is
You want any cereal or anything?
Exhibit
How about
1A.
Exhibit 1.
Oh, this is Exhibit 1, and we can scroll through it briefly so that everybody understands what exhibit it is, and then we'll go through entering it into the record if approved.
Madam Chair, this is Daniel Timmons with Wild Earth Guardians. I'm simply seeing a gray screen being shared. I'm not sure if this is on my end or if everyone else is having the same problem.
I think it's a common problem.
This is Doug. John, I also am getting just the gray screen.
Okay, give us a second. Can you see it now?
No.
No.
No, Madam Chair.
Miguel, do you want to sign in and then share the exhibits from your computer? Okay, we're going to try an alternative mechanism. Again, I apologize. Bear with us.
Shut down the meeting. Produced water is tracking waste. Shut down the meeting. Produced water is tracking waste. Shut down the meeting. Produced water is tracking waste. Shut down the meeting. Produced water is tracking waste.
You can stop. Galen, go ahead and mute it for now while we're trying to figure.
Produced water is toxic waste. Shut down the meeting. Produced water. Produced water is toxic waste. Shut down the meeting. Produced water is toxic waste. 6 million people have died according to the WHO because of
Mr. Carver, we have already issued you a warning, and we are going to expel you from the meeting. You were issued a warning earlier about interrupting the meeting. This is your second time doing that, and you will be expelled from the meeting. We will continue to hold decorum within this meeting. This is a public hearing. We have posted a link to Exhibit 1 in the chat. Everything can be found on the OCD hearings page. If you type in case, if you go to the case files 21281, but Exhibit 1 is copied into chat.
Communities on the front line of fracking. We give thanks to our table host,
Madam Chair.
Radioactive waste on the roadways, fields, and waterways. And that's what the Supreme Court is setting the ground. This is our new
If we keep having
road
meeting
construction
disruptions,
and maintenance for
we
irrigation.
again, this is your warning. If you
This
keep interrupting the meeting, we will remove you from the meeting. This is your warning.
station that despite their produce
You're welcome to continue with the video, but the
use for
audio
our
needs
roads.
to
Our
be eliminated.
In New Mexico.
You said this is your final warning.
Now
If you continue to do this, we will remove you from the meeting.
environment. Industry. Gallons of waste they are producing every.
They're gonna keep. Is there a way to? Galen, would you mute it? All of the parties who have entered appearances, we posted the link in there. Please let us know once you've reviewed that, and we will move forward.
Madam Chair, this is Douglas Mickle-John. When you said reviewed that, did you mean Exhibit 1?
Yes, sir.
Thank you.
I'm sorry, is somebody speaking? This is the court reporter.
We're going to take a 20-minute break. We'll be back approximately 10:05. For everybody who's entered an appearance, we will be trying to email you all of the exhibits in the meantime, so please watch out for those. Please review them. And then at 10:05, we will come back with a status update and try to hear from you as if you've been able to see the exhibit. Thank you.
Welcome to WebEx. Enter your access code or meeting number followed by pound. Enter your attendee ID number followed by pound. If you do not know your attendee number, press pound to continue.
Okay, awesome.
Hello, everyone. Just to give you an update, we're still working on sending those files. They're quite large. It looks like we got 3 of 5 packets through, so there should be 2 more coming. Have the parties received any of those emails, any of the 3?
This is Daniel Timmons with Wild Earth Guardians. We have received, or I have received the first two of those packets. My co-counsel's email appeared to be incorrect there, but I forwarded them to her, Ms. Roskavich Bars.
Okay, great. Well, there should be two more coming. The files again are quite large, so it may be a little bit of a delay. Taylor. Hello, everybody. Thank you for being patient. The exhibits have been sent out to the parties. Parties, I'll call you one by one. Can you confirm whether or not you have received the exhibits? 5 emails. There should be 37 total. Okay, Oil Conservation Division.
We received them.
Namoga.
Yeah, Madam Chair, members of the commission, we received them and had access to them well in advance of this hearing because of the posting on our division's website.
Thank you. Wildwood Guardians.
Yes, Madam Chair, we have received them.
Sierra Club.
Madam Chair, this is Douglas Mickeljohn. I have not received them, but that may be because my phone, wait a minute. No, they just came through on my phone. I apologize.
Okay, great. New Energy Economy, have you received them? New Energy Economy?
Sorry, I was on mute. Sorry, I was on mute. I'm just trying to download them now. Did you say that there are 37 hearing exhibits?
Correct.
Yes, I have.
Okay, great news. Thank you, everybody, for your patience. Okay, so I think we're gonna go back, and then we'll walk through Exhibit 1, and we'll try this again. Commission Counsel, can you please present the exhibits?
Yes, Madam Chair, and let me just say the 37 that were pushed out right now, those are what we had received as of 5 p.m. last night. We will likely have to enter additional exhibits either after a break, lunch break, or tomorrow morning. And we'll make sure to get all of those to the parties beforehand tomorrow morning. So we'll start with Exhibit 1, Commission Certificate of Compliance with Notice Requirement with the following exhibits. 1A, the
Mr.
legal notice.
Lozano, this
Yes.
is Irene, court reporter. Could I get you to speak a little louder, please?
Sure.
Thank you. I appreciate it.
I'll try to slow down as well. I forget.
Yeah, I'm sorry. It's not you guys. It's just the platform. But thank you so much.
Yes, ma'am. Exhibit 1, Commission Certificate of Compliance with Notice Requirements with the following exhibits. 1A, the legal notice published in the New Mexico Register on June 9th, 2020. The legal notice, 1B, the legal notice published in the Albuquerque Journal on May 29th and 30, 2020. 1C, notice of rule hearing posted on board's website on May 26, 2020.
Okay.
1D, notice of rule hearing posted on Sunshine Portal. 1E, OCD notice sent to Small Business Regulatory Advisory Commission.
Thank you, Mr. Lozano. Are there any objections of admitting these into the records from any of the parties? Okay, there are no comments.
Madam Commissioner, this is Marielle Nanasi. I'm with New Energy Economy. I would object because to all these exhibits being entered into the record, and I will explain why. I believe that you started this meeting saying that this meeting was going to be held pursuant to the Open Meetings Act. I believe that failure to provide these documents to the people who are on this call, I think that there may be like 100 or something, is a violation of the Open Meetings Act. To send them to just the attorneys of record is not in compliance with having an open meeting. And that is my stated objection to not only Exhibit 1, but all the exhibits, because I don't think that this complies with the statute.
Thank you for your comment. The Open Meetings Act does not require that the documents are submitted to all of the members of the public. And therefore we will, commissioners, do you have any questions on exhibits 1A through E?
No, this is Tom Engler. I have no questions or concerns.
No, I have no questions. Okay, exhibit 1A through E will be admitted into the record. And the objection from New Energy Economy is overruled. 1A through E will be entered into the record. Mr. Lozano, will you discuss exhibit 2?
Yes, Madam Chair. Exhibit 2, the draft proposed amendments to Board Rules 19.15.2, 19.15.16, and 19.15.34 NMAC related to produced water. Those were provided as part of the OCD's application.
Any of the parties, do you have an opposition to entering this into the record?
Madam Hearing Examiner, this is Marielle Nanassi, and I would just make a continuing objection so I don't have to interfere with your process. If you will acknowledge the objection and overrule it if you deem appropriate.
Thank you, Ms. Nanassi. Your objection on exhibit 2 is overruled. The documents were provided to the parties as is pursuant to the Open Meetings Act. Commissioners, do you have any objections about entering exhibit 2 into the record?
No question.
Exhibit 2 is entered into the record. Mr. Lozano, exhibit 3.
Madam Chair, exhibit 3, OCD's pre-hearing statement, including the following exhibits: 3A, proposed amendments; 3B, House Bill 546; 3C, written testimony of Bill Branker, General Counsel for MNERD; 3D, proposed modifications from the New Mexico Oil and Gas Association; 3E, PowerPoint presentation of Bill Branker; 3F, Form C-105; 3G, proposed water use report; and 3H, certificate of compliance with notice requirements, which were also admitted as exhibit 1.
Parties, other than New Energy Economy's ruling objection, which has been overruled, are there any objections to entering this into the record?
I have an objection. I don't know if I can be heard. Can you tell me that I'm being heard?
Yes.
Hello? Sorry, this is Dr. Valerie Gremion, and I would like to make a request. Could you please, since many of us do not have the opportunity to review these submissions, could you please do at least a short summary of each of these documents, even like this is where the actual rules are, or this is a I mean, you're sort of doing that, but there's no content whatsoever. So in the light of the intention of the Sunshine Rule, I would really appreciate if some level of sunshine were provided with, a description of these. Like, in other words, a description of that this is a presentation is not sufficient. Is it a presentation of the actual rules by MNERD? Is it a presentation of the proposed rules by Oil and Gas? I would simply appreciate that. Thank you very much.
Thank you for your note. I think first item here is right now only the parties who have entered an appearance are able to participate and speak at this time. And then secondly, they are all on the OCD website. If you go to the OCD website, go to hearings. If you go to OCD imaging and type in the case number, all of these items will pop up and you're welcome to review those at your leisure. Okay, exhibit 3, are there any objections from the parties to entering these into the record other than New Energy Economy's rolling objection, which has been overruled? Okay, I will take the silence as there are no objections from any of the parties. Commissioners, do you have any objections?
No objections or questions.
No questions or objections from the commissioners. Exhibit 3 will be entered into the record. Mr. Lozano.
Madam Chair, Exhibit 4, pre-hearing statement from the New Mexico Oil and Gas Association, including proposed changes to the draft proposed rule.
Thank you, Mr. Lozano. Parties, do you have any objections to entering in Exhibit 4? Other than New Energy Economy's rolling objection, which has been overruled. Okay, I will take silence as there are no objections from any of the parties.
I apologize, Madam Chair, I was on mute. I was attempting to object. This is Daniel Timmons with Wild Earth Guardians. I object to the entrance of Exhibit 4. This document was improperly served. As indicated in the certificate of service, it was emailed to Cheryl Beta as opposed to Florine Davidson, which is required under the procedural order for this matter. That is the proper means of filing a document. This is a substantive error because of that result, this document was not placed on OCD's website on July 17th, but not until July 27th. I believe that Wild Earth Guardians and the other participants are prejudiced by the participation of NMOGA as a party in this proceeding.
We're not during our class I'm teaching.
So at the time, it was served to the only other party of record, was Cheryl Beta. And it has been on the portal for a number of days now. So your objection is overruled. Are there any other objections from any of the other parties? Commissioners, do you have any objections to entering in Exhibit 4?
No objections, Madam Chair.
Exhibit 4 is entered into the record. Mr. Lozano, will you discuss Exhibit 5, please?
Yes, your Exhibit 5, pre-hearing statement from Wild Earth Guardians, including proposed changes to the draft rule. Exhibit 5A, EPA report, hydraulic fracturing for oil and gas, impacts from the hydraulic fracturing water cycle on drinking water resources in the United States. 5B, journal article, produced water in the western United States, geographical distribution, occurrence, and composition. 5C, journal article, unconventional oil and gas development and risk of childhood leukemia, assessing the evidence. 5D, journal article, endocrine disrupting chemicals in oil and natural gas operations, potential environmental contamination, and recommendations to assess complex environmental mixtures. 5E, PowerPoint, New Mexico Environmental Department report on ozone attainment initiative. 5F, article, EPA radiation waste material from oil and gas drilling. 5G, article, America's radioactive secrets from the Rolling Stone. 5H, journal article, an integrative method of identification and prioritization of constituents of concern in produced water from onshore oil and gas extraction. 5I, search results from NMOCD permitting spill search database. 5J, it was raining, or article, it was raining on us. Family awoken by produced water, pipe burst near Carlsbad. 5K, EPA report, exemption of oil and gas exploration and production waste from federal hazardous waste regulations. That's all of the Exhibit 5 sub-exhibits.
Before addressing the parties, I want to confirm, since that was a lot, that the court reporter was able to gather that information.
I am. Thank you.
Thank you. Parties, do you have any objections to entering Exhibit 5 into the record?
I have a question. I apologize for interrupting again. This is Dr. Valerie Gremion. As we only have a listing of titles of documents, which again are many dozens, I would formally request that Mr. Lozado please reference the name of the actual file, which you guys should be able to see on your own website there. And that way we can actually open up the relevant documents to check whether or not the official filing people have a reason to object. Right now, we cannot search through 100 documents to find the one that you are mentioning, as they are not labeled as such, and that would be very appreciated.
Okay, ma'am, thank you. Please do not interrupt again. This will be your warning. Right now, this is being addressed to the parties. All of the documents are available on the OCD portal, and right now we are addressing the parties who have entered in appearances. If you wish to participate in this type of manner in the future, you must enter an appearance. Thank you. Exhibit 5. Parties, do you have any objections to this being entered into the record? I'm hearing no objections. Therefore, I take that as no issues with it being entered into the record. Commissioners, do you have any questions or concerns with entering in Exhibit 5? No questions or objections.
No questions, no objections.
Thank you. Exhibit 5 is now entered into the record. Mr. Lozano, Exhibit 6.
Yes, Madam Chair. Exhibit 6, Sierra Club pre-hearing statement. 6A, resume of Camilla Catherine Engelman. 6B, resume of Norman Guam. 6C, written testimony of Norman Guam. 6D, proposed changes to draft rule. And 6E, which was filed separately, notice of errata for pre-hearing statement of Sierra Club.
Thank you, Mr. Lozano. Parties, do you have any objections to entering in Exhibit 6 to the record? I'm hearing no objections from the parties. Commissioners?
No. No objection.
Thank you. Exhibit 6 is entered into the record. Exhibit 7, Mr. Lozano.
Madam Chair, Exhibit 7, pre-hearing statement of new energy economy.
Are there any objections from the parties entering in Exhibit number 7 to the record? I'm hearing no objections from any of the parties. Commissioners, do you have any objections?
No. No objection.
Thank you. Exhibit 7 is entered into the record. The following exhibits are written comments.
Madam Chair, if you will allow me, I will take these in turn, maybe in sets of 5, and we can hopefully admit them in batches. Beginning with Exhibit 8, written comment received from Amigos Bravos. Exhibit 9, written comment received from the Environmental Defense Fund and Audubon, New Mexico. Exhibit 10, written comment received from Walker Durrell. Exhibit 11, written comment received from Catherine Smith. Exhibit 12, written comment received from Diane Forsdale. I'd ask that you'd admit Exhibit 8 through 12, Madam Chair.
Madam
I apologize.
This is Marielle Nanasi. According to what you sent us, actually Exhibit 12 is the written comment of Megan Schendel.
Yes, Mr. Lozano made an error. Ms. Lozano,
Okay.
to restate.
Yes, ma'am. So Exhibit 12 is actually a written comment received from Megan Schendel. My apologies.
Thank you. Let the record reflect the change to Exhibit 12. Parties, do you have any objections to admitting exhibits 8 through 12? I'm hearing no objections. Commissioners?
No objection.
No objection.
Exhibits 8 through 12 are admitted into the record. Exhibit number 13, Mr. Lozano?
Yes, Madam Chair. Exhibit number 13, written comment received from Diane Fortdale. Exhibit number 14, written comment received from Jeff Selesky. Exhibit number 15, written comment received from Mike Nayes. Exhibit number 16, written comment received from Robert Inglis. And exhibit number 17, written comment received from Erica Bell Benedetti.
Thank you. Parties, do you have any objections to entering in exhibits 13 through 17? I'm hearing no objections. Commissioners?
No objection.
Exhibits 13 through 17 have been entered into the record. Mr. Lozano?
Madam Chair, exhibit number 18, written comment received from Elaine Domino. Exhibit number 19, written comment received from the State Land Office. Exhibit number 20, written comment received from Lonnie Rowell. Exhibit number 21, written comment received from Justin Nobel with 2 attachments, 21A, article, norm contamination in the petroleum industry. 21B, article, an analysis of the impact of the regulation of radionuclides as a hazardous air pollutant on the petroleum industry. Exhibit number 22, written comment from Kelly Lee.
Parties, are there any objections to entering in exhibit number 18 through 22? I'm hearing no objections from the parties. Commissioners, do you have any objections?
No objection.
No objections. Exhibits 18 through 22 will be entered into the record. Mr. Lozano?
Madam Chair, exhibit number 23, written comment received from Laura Brookins. Exhibit number 24, written comment received from Thomas A. Mabilia. Exhibit number 25, written comment received from Karen Cohen. Exhibit number 26, written comment received from Richard Welker. Exhibit number 27, written comment received from Diane McInnes with 3 subparts. Article, exhibit number 27A, article, regulation lacks as gas wells, tainted water, hits rivers. 27B, article, wastewater recycling, no cure-all in gas process. 27C, article, wastewater byproducts of shale gas drilling and fracking.
Parties, do you have any objection entering in exhibits 23 through 27? I'm hearing no objections from any of the parties. Commissioners?
No objection.
No objection.
Exhibits 23 through 27 are now entered into the record. Mr. Lozano, number 28.
Madam Chair, exhibit number 28, written comment received from Rebecca Sobel, including a letter from tribal governments and other organizations. Exhibit 29, written comment received from Joa DeTilo. Exhibit 30, written comment received from Anita Rodriguez. Exhibit number 31, press release from the Coalition for Clean, Affordable Energy provided by Rebecca Sobel. Exhibit 32, written comment received from Annie Hanna.
Thank you. Parties, do you have any objections to entering in exhibit 28 through 32? I'm hearing no objections from the parties. Commissioners, do you have any objections?
No objection.
No objection.
Exhibit 28 through 32 are now entered into the record. Mr. Lozano?
Madam Chair, exhibit number 33, written comment received from Jean Arbaugh. Exhibit number 34, written comment received from Barbara Conroy. Exhibit number 35, written comment received from the New Mexico Environment Department. Exhibit number 36, written comment received from Robert J. Baruti. Exhibit number 37 includes all requests for oral comment as of 5 p.m. yesterday. That were in the case file.
Thank you. Parties, do you have any objections to entering exhibits 33 through 37? I'm hearing no objections from the parties. Commissioners?
No objection.
Thank you. Exhibits 33 through 37 have been entered into the record, which concludes all of the exhibits.
Madam Chair, if I may, there has already been additional written comments and requests. We will attempt to admit those at a proper junction either this afternoon or tomorrow morning.
Thank you, Mr. Lozana. If there are no other preliminary matters, we will now hear opening statements from the identified parties. Parties that plan to call witnesses may reserve their opening until the beginning of their presentation of testimony.
Thank you, Madam Chair. I do, in fact, have a few preliminary matters that I would like to address before we get to opening statements. This is Daniel Timmons with Wild Earth Guardians.
Please proceed.
So as an initial matter, we're concerned that no agenda was made publicly available before this meeting 72 hours in advance as required under the New Mexico Open Meetings Act. The public notice for this hearing that was distributed also specifically indicated that the commission would make a preliminary agenda available 2 weeks in advance and that final agenda at least 72 hours before the meeting. To date, no one outside of the commission, to my knowledge, has in fact seen that agenda. Under OCD's rulemaking procedures at Title 19, Chapter 15, Part 3, 13A, it's clear that at the very least, the commission cannot take any action on this rulemaking proposal as part of this hearing because there has been no agenda provided, informing the public that such a decision will be made here. We would encourage the public, in particular in light of the technical difficulties that we've had, we would encourage the commission to provide an additional opportunity for public comment prior to any decision on this matter. That is my first objection. My second objection relates to the statement made earlier that individuals offering public comment here today would be subject to cross-examination. That procedure is not contemplated under the commission's rules or under the procedural order for this hearing. There's a distinction between non-technical oral testimony, for which cross-examination is permissible, and unsworn public comment, for which it is not. Subjecting the public to cross-examination in order to offer a public statement here at a public meeting is a chilling repression of free speech and raises serious concerns under the First Amendment and under the procedures of this body. That is my second objection. My third request would be that the chat that is currently ongoing in this WebEx hearing be incorporated as part of the public record of this meeting. I think it provides important indications regarding the technical difficulties and the inability of the public to participate and to fully apprise themselves of these proceedings and of the public business that is being conducted here today. Finally, I will, I guess, second the objections of Dr. Vermillion that the documents which OCD has made available on OCD's website are inadequate to inform the public of what's going on, in particular because those documents, and there's more than 100 of them on there, are simply labeled by the file size and the date of upload. And so there's no indication for the public. It's very limiting for the public's ability to be able to track these documents and to find the exhibits that are being discussed. So I would object to that being a serious problem of allowing the public to participate, follow these proceedings, and inform their public comment when that opportunity arises. So those are my 4 objections or requests.
Okay, I'm going to try to make sure I cover each one of them. For your first objection regarding the agenda has been posted on the website for a significant amount of time. That objection is overruled. I believe your second objection was regarding cross-examination. That was noticed within the rule hearing kind of the order and notice. And so that procedure is well established. That is also overruled. Your other item regarding the documents not being made available to the public, again, those are all on the OCD website. You can click on each one of them and determine which it is. Therefore, that objection is overruled. I believe you had 4. Which one am I missing?
I've also requested that the chat be incorporated as part of these proceedings.
If that's possible, we will incorporate those. This is being recorded, which I believe records the chat. We'll have to confirm that, but if it is, if we're able to do that, we will enter that into the record. I believe that addresses your 4 items. Okay, I'm hearing no other items. Are there any other preliminary matters from any of the parties? Thank you. Does the Oil Conservation Division wish to make a brief opening statement?
The OCD would like to make an opening statement.
Thank you. Please proceed.
Madam Chair, Commissioners, as discussed in William Brainard's written testimony, the Oil Conservation Commission filed this application proposing amendments to the Commission's rules in case number 21281 for limited purposes. Those 3, the first is amending the language regarding the division's authority over produced water in the Commission's existing rule 1915-34 NMAC so that it reflects and does not conflict with the changes that were made by Laws 2019, Chapter 197, otherwise known as House Bill 546, to the division's authority over produced water. That authority is codified at NMSA 1978. Section 70-2-12B15. The second change is to amend the definition of produced water in the Commission's rules at 1915-7P NMAC to conform to the change the legislature made to that definition in House Bill 546. That definition is codified at section 70-2-33K. That change simply changed the word water to fluids. And then finally, the third purpose of the amendments is to add a section to 1915-16 NMAC requiring the filing of a water use report for a hydraulically fractured well that specifies the portion of water used in fracturing by 3 different types. The first is the use of recycled produced water. The second is the portion of water that is not recycled produced water and contains 1,000 milligrams per liter of total dissolved solids or more. And finally, the third is that portion of the water which contains less than 1,000 milligrams per liter of TDS and is not recycled produced water. Prior to the enactment by the legislature of House Bill 546, Section 70-2B15 provided that the division could adopt rules to regulate the disposition of water produced or used in connection with the drilling for or the producing of oil or gas or both, and to direct surface or subsurface disposal of the water, including disposition by use in drilling for or production of oil or gas, in road construction or maintenance or other construction, in the generation of electricity or in other industrial processes in a manner that will afford reasonable protection against contamination of fresh water supplies designated by the state engineer. With the enactment of 546, Section 70-212B15 now provides that the division may adopt rules to regulate the disposition, handling, transport, storage, recycling, treatment, and disposal of produced water during or for reuse in exploration, drilling, production, treatment, or refinement of oil and gas, including disposal by injection pursuant to authority delegated by the Federal Safe Drinking Water Act in a manner that protects public health, environment, and freshwater resources. Given the legislative change, provisions such as those in the Commission's current rule, 1915-34, Section 2, which provides that the division regulates produced water used in road construction or maintenance or other construction, or in the generation of electricity or in other industrial processes, no longer reflects the division's authority and conflicts with the authority provided in Section 70-2-12B15. The authority to adopt rules regulating the discharge, handling, transport, storage, recycling, or treatment, or the disposition of treated produced water, including disposition in road construction, maintenance, roadway ice or dust control, or other construction, or in the application of treated produced water to land for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil or gas, is now provided in the Water Quality Act to the Water Quality Control Commission. The purposes of this limited rulemaking application was not to propose new substantive requirements or amend existing substantive requirements in the Commission's rules. Those are beyond the scope of the amendments proposed in this matter and would need to be proposed as a separate rulemaking with notice provided to the public of those proposals. As such, much of the written comment and testimony that has been provided and the proposed modifications that were submitted are outside the scope of this rulemaking and the public notice that was provided regarding this rulemaking. If the Commission wishes to consider them, it would need to initiate a new rulemaking process and provide public notice that included those proposals. House Bill 546 created parallel produced water regulatory roles for the Oil Conservation Division and the New Mexico Environment Department. The division has worked and will continue to work with the Environment Department on research initiatives and policy development regarding produced water. The division is part of the Produced Water Research Consortium and it is coordinating and will continue to coordinate with the Environment Department on future rule development regarding produced water. Thank you.
Ms. Dana. Does Namoga wish to make a brief opening statement?
Madam Commissioner, a question please, as to order. Is there going to be a chance to cross-examine Ms. Bada on her statement?
No, this is just an opening statement. There's no opportunity to cross-examine an opening statement. Mr. Feldor, does Namoga wish to make a brief opening statement?
Madam Chair, members of the Commission, we appreciate the opportunity to be involved. We appreciate the effort that the division has put forth here to put together some limited regulatory changes for the purpose of matching up with the Produced Water Act, which we know was passed by the legislature to encourage the recycling and reuse of produced water. We have a few minor comments, which Mr. Brankford has addressed, and we can discuss in more detail at the appropriate time. I think the only observation I have is the disappointing representations that have been made by parties in this case as to what this rulemaking is all about. And it certainly has nothing to do with dumping produced water onto crops or into state streams or any other type statements that we have seen from parties in this case, which completely misrepresents the purpose of this rule and leads to nothing but unnecessary and unguided consternation. With that said, we appreciate the efforts you've made here and have no further need for statements.
Thank you, Mr. Feldorf. Does Wilder Gardens wish to make a brief opening statement?
Yes, Madam Chair.
Please proceed.
Madam Chair, members of the commission. Again, this is Daniel Timmons. Oh, sorry, I'm getting feedback.
It's okay on our end.
Okay. Madam Chair, members of the commission, Daniel Timmons again on behalf of Wild Earth Guardians. The Produced Water Act authorized OCD to promulgate rules to regulate produced water, quote, in a manner that protects public health, the environment, and freshwater resources. In its public notice for this hearing, the purpose of the proposed rule was to implement the changes in produced water management and authority enacted by HB 546. OCD's proposal, however, does nothing to implement the statutory directive and does nothing to effectively protect public health, the environment, and freshwater resources as the legislature intended. We ask the Commission to direct OCD to go back to the drawing boards to develop substantive rules to implement scientific, specific, measurable standards to ensure that the recycling and reuse of produced water is handled safely and responsibly. Guardians has provided red line edits as a start at putting meat on the bones of OCD's proposal. But we believe that the best course of action would be for the division to take a big step back, to convene a much more robust public process, engage scientific experts before coming back to the Commission with a substantive proposal to actually regulate produced water in a manner that protects public health, the environment, and freshwater resources. There are huge gaps in the scientific understanding of the toxicity and risks associated with the reuse of produced water. But what we do know should make this Commission pause before allowing the division to allow essentially the unrestricted use of produced water within the oil and gas industry. As the EPA has acknowledged, produced water contains a wide range of contaminants that threaten public health and the environment, including high salt levels, dissolved organic compounds, metals, and fracking chemicals. Produced water contains toxic materials including barium, cadmium, chromium, lead, mercury, nitrate, selenium, and BTEX, as well as acetone, ethylene glycol or antifreeze, phthalates, propylene glycols, and dozens of other toxic chemicals. And these can have significant adverse effects on human health, including causing cancer and disrupting the endocrine system. According to the EPA, produced water can also contain radioactive materials, including radium, radon, uranium, potassium, and thorium. And produced water from the Permian Basin has been specifically shown to contain significant levels of uranium. Accordingly, the extraction, handling, transportation, and reuse of produced water poses a serious threat of widespread radioactive contamination here in New Mexico. As the EPA has acknowledged, once oil and gas has been extracted from the formation, workers and members of the public may be exposed to radionuclides that are brought to the surface. And perhaps even more troubling is what we don't know, because the toxicity of the vast majority of the chemicals found in produced water has never been studied. One recent scientific analysis found that 86% of more than 1,000 chemicals found in produced water do not have established toxicity thresholds. And only 1/4 of the chemicals found are even detectable based on standard analytical methods, which poses a huge barrier to fully understanding the public health and environmental risks of produced water. And the industry's track record with handling produced water does not support OCD's proposal to continue its hands-off approach to regulating this toxic waste. OCD records show more than 7,000 spills of produced water since July 2010. And in the first 6 months of this year alone, there have been 325 documented produced water spills, including 171 major spills. A major spill nearly every day here in New Mexico. And these are not just industrial accidents. In January of this year, a produced water pipe burst in Otis, New Mexico, and soaked a family home, their yard, their animals, and their bodies when they went outside to investigate. Now, the Produced Water Act attempted to draw a jurisdictional line between the reuse of produced water in oil and gas activities regulated by OCD and its potential reuse for other purposes to be regulated by the Water Quality Control Commission. But as the disaster in Otis made clear, there is no clear line between the oil fields and the communities of New Mexico. OCD's proposed rule ignores this reality and treats produced water as a largely benign byproduct of oil and gas production, appearing to assume that any risks of produced water reuse can be assumed by the industry alone. That is simply not the case. The production, storage, handling, transport, recycling, and reuse of produced water for oil and gas activities poses real risks to public health, the environment, and freshwater resources, risks that extend well beyond the oil fields. And OCD's proposal does nothing to address these risks. Accordingly, we ask that the Commission reject OCD's proposal and direct the division to come back with a robust regulatory proposal with specific, measurable, and enforceable standards that are actually designed to ensure the protection of public health, the environment, and freshwater resources, as the legislature intended. Thank you.
Thank you. Does the Sierra Club wish to make a brief opening statement?
Yes, Madam Chair, members of the Commission, this is Douglas Mickeljohn. I'm a lawyer with the New Mexico Environmental Law Center, and with my co-counsel, Kara Lynch, we represent the Rio Grande chapter of the Sierra Club. We believe that the regulations need to be modified in order to reflect the actual intent of the Produced Water Act as enacted by the New Mexico legislature. The regulations need to be strengthened with respect to indicating that produced water will be regulated so as to protect public health, the environment, and freshwater resources. We also believe that the regulations need to be strengthened to indicate that fresh water will not be used in hydraulic fracturing operations if either produced water or other alternatives are available. We will present 2 witnesses who will testify concerning these issues. Ms. Lynch will present Camilla Feibelman, who is the director of the Rio Grande chapter of the Sierra Club, and I will present Norman Gaum, who is a geohydrologist with many years of experience in water quantity and water quality issues. We look forward to making that presentation to the commission. Thank you.
Thank you, sir. Does the new energy economy wish to make a brief opening statement?
Yes, thank you, Madam Chair and Commissioners. Good morning, and thank you for the opportunity to allow New Energy Economy to participate in this very important hearing. 2 days ago, I received an email from Governor Michelle Lujan Grisham, and this is how it began, and I quote, "From day one, my administration's response to COVID-19 has been grounded in science and data. The only way we get through this pandemic is if we take to heart what public health experts have to say. It's the best thing we can do to protect ourselves and our loved ones. As we look toward school starting up again in the fall, those decisions have got to be grounded in the science and the data too, which is why I'm delaying in-person classes until after Labor Day." She went on to state that, quote, "Donald Trump is ignoring guidance from his own CDC, unquote, and lamented, quote, "Look, I wish things were different." The governor was talking, of course, about the devastating coronavirus and the opening of schools. But what we are here to tell you is that this body must apply the same legal, medical, social, and moral standards to the situation at hand. This proposed amendment to the, quote, produced water rule must be denied or at least delayed because it is not grounded in science and data and is contrary to what the scientific experts, including oil and gas industry experts, admit. There is radiation in fracked toxic waste. Governor Lujan Grisham was forced to delay school opening because the facts don't support that move. We must also exercise extreme caution and rely on science, not political expediency, because it is, in her words, the best thing we can do to protect ourselves and our loved ones. To do otherwise would be irresponsible in the extreme and perhaps knowingly criminal. Before you promulgate any new rule, it is incumbent that you take a hard look at the existing science that warns against allowing the use of wastewater from oil and gas wells to be used at all outside the oil fields. For instance, Pennsylvania State University has found that spreading fracked wastewater on unpaved roads control dust, which contains high levels of the carcinogenic and radioactive element radium, inorganic salts, and oil and gas hydrocarbons, is a threat to human health and the environment. That 2018 study shows that these harmful components are likely leaching off roads into surrounding soils and water. It further found Pennsylvania from 2008 to 2014, spreading oil and gas wastewater released over 4 times more radium to the environment than oil and gas wastewater treatment facilities, and 200 times more radium than spill events. That study is reported in Environmental Science Technology 2018, and for the record, DOI:102./ACS.EST.8E00716, and is cited in New Energy Economy's pre-hearing statement at page 2. As a result of this study and dozens, or if not many dozens of studies, Pennsylvania and 4 other states have banned road spreading of wastewater from hydraulic fracturing wells. This hard look is aimed at ensuring that governmental agencies consider every significant aspect of the environmental impact and assures the public that you have indeed considered environmental and health concerns. All foreseeable direct and indirect impacts, as well as cumulative impacts of a proposed action must be analyzed. I will cite to one other study. It's a 2018 university study published in a peer-reviewed policy paper on January 4th, 2018 in Environmental Science and Technology. And it too concluded that disposal of treated conventional oil and gas waste is the source of high radium concentrations in stream sediments. The study found high levels of radioactive material in river and stream sediments at levels up to 650 times those found in 3 industrial waste treatment plants that handle the fluid. As a response to the overwhelming evidence, including health and scientific studies that are available, easily available, just with Google searches, of the risks and harms of fracking, there have been a number of states, countries, municipalities that have issued bans on fracking. I won't cite all of them, but I want to give you a flavor. France banned fracking in July 2011, Bulgaria in January 2012. In May 2012, the state of Vermont banned fracking. In July 2014, Belgium temporarily banned fracking, and this ban is still valid. New York State has banned fracking since December 2014. In March 2015, the Canadian province of New Brunswick declared a moratorium on fracking. In 2016, New Brunswick extended its moratorium on fracking indefinitely. In April 2017, Maryland became the 3rd U.S. state to ban fracking. In November 2018, the Delaware River Basin Commission, which consists of governors from the 4 states of New York, New Jersey, Pennsylvania, and Delaware, together with the U.S. Army Corps of Engineers, released a rule to ban fracking in the Delaware River watershed, and that de facto moratorium still exists. On May 8th, 2019, Washington State enacted a statewide ban on fracking. In May 2019, the Oregon Senate passed a 5-year fracking moratorium. On June 17th of 2019, the governor signed the bill into law. Extensive empirical data has confirmed that the public health risks from unconventional gas and oil extraction are real, the range of adverse environmental impacts wide, and the negative economic consequences considerable. Any examination of the peer-reviewed medical, public health, biological, earth sciences, and engineering literature evidence that fracking cannot be practiced in a manner that does not threaten human health, animal well-being, and damage our environment. I could go on, but what I want to tell you is that this rulemaking is entirely premature. It is not based in science. And if you are to follow the edicts of this governor and this legislature, there's no way that you can say that this rulemaking is consistent with 19.15.34.6, which the OCD, Ms. Bada, cited as protecting public health, environment, and freshwater resources. We ask that you deny this rulemaking at this time and conduct the proper background scientific study. And I will end with this. There is the 6th edition of the Compendium of Scientific, Medical, and Media Findings demonstrating risks and harms of fracking from unconventional gas and oil extraction, produced in June 2019. And that should be all of your bedside material. It must be included in this record. It can be found at concernedhealthynewyork.org, and it is the foundational document that lists hundreds, I mean hundreds of studies about air pollution, about water contamination, about health and environmental risk that must be included not only in this hearing, but any proper evaluation of this pool. Thank you.
Thank you all for your for your opening statements. We will now move into the public comment period. We will move to the first round of public comment. I have been provided with a list of all individuals that have requested to provide public comment at this hearing as of yesterday at 5 p.m. When you are called, please unmute yourself, your audio, and identify yourself for the records, as well as any affiliation that you have. I would also like to remind members of the public that you have 5 minutes for your comments, and that, as we stated at the beginning of this hearing, because of some of the commentary that people have had a hard time understanding what the procedure was, we extended the public comment period and the ability to email Lauren Davidson with your request to make public comments till 3 p.m. today. Anything in addition to the public comment that we hear today, and we receive requests by today at 3, we will hear tomorrow morning. We will call everybody's name who's on the list today. If we do not, if you are not here with us, we will call your name again tomorrow. So you will be given multiple opportunities to provide public comment here. Again, just a reminder, each person has 5 minutes. As we hit the 5-minute mark, I will remind speakers that they need to wrap things up. All right, we will move into public comment. I apologize in advance if I mess up anybody's names. First is Joe Zapan. Joe, are you with us? If so, please unmute yourself and state any affiliation that you may have. And then you have 5 minutes.
Madam Commissioner, this is Marilyn Nassi again from New Energy Economy. It's a regular practice, at least in front of the PRC, for the in your case, you name a couple of people in advance so people can know who's coming up next. So if you wouldn't mind, that would help people prepare to get ready. Thank you.
Yeah, sure, no problem. I'd be happy to do that. I'll list them in threes. Joe Zapan is number 1. Michelle Hunter is number 2. Rebecca Sobel is number 3. Number 1, Mr. Zapan, are you with us? If so, again, you have 5 minutes. Please unmute yourself and list any affiliations that you may have. Mr. Zapan, are you with us today? Okay, we will call your name again tomorrow. Michelle Hunter, are you with us?
I am here.
Unmute yourself and state your affiliation for the record.
Madam Chair and Commissioners, my name is Michelle Hunter and I'm the Chief of the Groundwater Quality Bureau at the New Mexico Environment Department.
Thank you. Please proceed. You have 5 minutes.
Hello, everyone. My name is Michelle Hunter and I'm the Chief of the Groundwater Quality Bureau at the New Mexico Environment Department, or the NMAC. I've been the Chief of the Bureau for 5 years. As many of you are aware, the NMAC has conducted several public meetings about the reuse of produced water over the course of the last year, and many of you have participated in those meetings. With respect to this proposed amended rule, which OCD is proposing in order to specify processes for reporting what is called generally fresh water usage, and to specify jurisdictional lines between the NMAC and the OCD, The NMED is here to support the OCD in drawing these lines and specifying freshwater reporting. NMED will have its own rulemaking in the fairly near future in front of the Water Quality Control Commission. After reading the Sierra Club's proposal to divide the water reporting into 3 categories instead of 2, the NMED concurs with the Sierra Club. And we have discussed this with the OCD prior to my remarks today. And I want to thank you for the opportunity to comment.
Thank you, Mrs. Hunter. Rebecca Sobel, are you with us today?
I'm here. Can you hear me?
We can. Would you please state your affiliation, and then you have 5 minutes.
Great. Thank you, Chair and Commissioners. My name is Rebecca Sobel. I'm the Senior Climate and Energy Campaigner for Wild Earth Guardians. Oh, I'm sorry. I'm a little bit floored because it was a little news to me to hear the representative from the Environment Department say that in the near future, they expect to promulgate rules related to produced water off field. That goes against, frankly, NMOGA's exact objection that these rules have nothing to do with making it easier for industry to dump and discharge their toxic waste all over our land and water. It's terrifying. I think, you know, my colleagues have submitted written testimony, and we have flooded the record with studies and science and proof that this commission, that these rules have failed to consider when they propose to make it easier to transport and reuse produced water in fracking operations. It's great that these rules for the first time propose to record the amount of fresh water and produced water used in fracking. Frankly, this is data that the state of New Mexico sorely needs before promulgating any rules related to the severity of the problem of managing this toxic and radioactive waste. I don't think it's out of line to say that this process is severely underserving the public. I mean, there are over 100 people in this meeting and over 100 documents that have been uploaded as a part of this rulemaking, and not a single one of them is in favor of the commission moving forward with these rules as proposed. So I don't know what we in the next few hours of folks can say to impress upon this administration the dire need to look before leaping. The risks to New Mexico's public health, our clean air, our clean water, are forever threatened if this commission moves forward as planned. So firstly, considering the lack of public engagement, the confusion around the circus of these proceedings, and the inability for the public to stay informed on this process, and the lack of information that the commission has before them in order to promulgate these rules, we are reasonably asking for a suspension of this rulemaking. The commission should not act until they have all of the information in front of them and have done the proper stakeholder engagement related to this process. Then if you're gonna promulgate rules related to toxic oil and gas waste, do them so that the health, the environment, and freshwater resources are protected. Nothing in these rules provide any safeguards or metrics that would point to any guarantees, let alone tracking that the public health, environment, or freshwater is served. And then finally, produced water is too toxic to treat, and there has not been nothing that this commission, that the EPA, that even the industry-funded Produced Water Consortium has provided that shows that produced water is any less toxic or any more treatable. And it's clear New Mexico has a problem managing this toxic fracking waste. We are running out of space to dispose it, and it's very costly for industry to manage it. But instead of making industry's liabilities New Mexicans' problems, we need to go to the source of the problem. And if there's too much toxic fracking waste to manage, we need to stop producing so much fracking waste. And the way to do that is to stop fracking and reduce production. Thank you.
Thank you. I apologize. Just a quick procedural thing. We are allowing cross for each public comment. So we will finish up with Ms. Sobel, and then Michelle Hunter, if you're still with us, we will open up for cross of that. And then we will move on to the next person. Going forward, it will be following each person. I apologize for the confusion. Parties, do you have any cross-examination requests for Ms. Sobel, OCD?
Do not.
Okay, I'll just open it up. Do any of the parties have any questions for Ms. Sobel? All right, I hear no questions. Do any of the party, Ms. Hunter?
I have a question for her.
So it has to be somebody who has entered appearance, one of the parties, either the Oil Conservation Division, so NMOGA, the New Energy Economy, Wildlife Guardians, or the Sierra
Oh, so
Club.
this is a regular citizen can't make a comment at this point. I see. Sounds kind of oppressive. Y'all are racists. Bye-bye.
Thank you for your feedback.
Also, Chairman Sandoval, could I just clarify? I wasn't aware that I was open to any cross-examination when offering to give public comment as opposed to non-technical oral testimony. Can you please clarify? I'm still confused and want to know, and I think other members on this or other public members on this call want to know if they're open to cross-examination.
Yes, so that was stated in the notice and the order. It is the standard practice for OCD rulemaking, and again, was part of the notice and the order in terms of procedure. So that will be part of this rulemaking hearing, which we also addressed earlier with Mr. Timmons, I believe.
Yes, Madam Chair, and I will reiterate that objection. I'm looking at that public notice again. There is a distinction between oral non-technical testimony and public comment that's embedded in the rules. And I do not believe that it is appropriate to subject members of the public to cross-examination. I believe it kills free speech and is a violation of your own regulations.
Madam Commissioner, this is Marielle Nanasi from New Energy Economy. I have been in dozens of administrative hearings in the state of New Mexico, and I have never seen anybody from the public giving public comment be subject to cross-examination, and I would object based on the statements that Mr. Timmons has already articulated. Thank you.
Commissioner Kessler wishes to make a comment.
We're unable to hear Commissioner Kessler.
I'd like to, can you hear me?
Yes, we can hear you.
Okay. I'd like to comment that I believe that there's a distinction between
I'm sorry, Commissioner Kessler, this is Irene, the court reporter, and I'm having difficulty. You're fading out. Maybe if you could pull your laptop to you, this part.
How about that?
I think so. Just speak loud.
I'd like to comment that I think that there's a distinction between adjudicatory and the rulemaking rules that apply to the Oil Conservation Commission. I do not believe following those rules that it's appropriate to cross-examine based on public comments, non-technical testimony. So I would be in favor of not having cross-examination apply to the public comment section.
Mr. Lozano, can we do like a roll call vote on or against?
I'm really sorry. So we can't.
Madam Chair, this is Irene, the court reporter. I need for all of you guys to stay by the speakers in your laptops that you're feeding into and to speak loudly. Please, thank you.
They're not in the laptop, they're on the screen at the front of the room, so we're having to really.
Okay, I understand. Thank you.
This is Tom Engler, Commissioner. I just want to clarify what Jordan said. So what you're saying is that rulemaking for public comment, there is or should not be cross-examination as defined by.
In my view, for under the rulemaking rules that apply to the oil conservation, cross-examination of public comment is not. So I would suggest we move forward without cross-examination of public comment.
I would make a motion to, going forward, have no cross-examination of public comment, which is distinguished from technical testimony. Do I hear a second on that motion?
I would second that motion.
I would do a roll call vote.
Commissioner Kessler?
Approved.
Commissioner Engler?
I approve.
Chair Sandoval?
Approved. We will move forward with public comment and distinguish from technical testimony. So going forward, there will be no cross-examination of public comment. Okay, we're moving down the list. The next three are Sonia Grant, Jennifer Bradbutte, and Thea Beckett. My apologies. Sonia Grant, are you with us today? Please state your name and affiliation, and you have 5 minutes. Ms. Grant, are you with us? So you need to unmute your phone. Okay. For Bradbutte.
Good morning, Madam Commissioner and members of the Commission. This is Dina Bennett, and I'm an attorney at Model Sperling, and I represent Marathon Oil Permian LLC. And Ms. Bradbutte isn't able to join us for public comment today. And I would just note that Marathon Oil Permian supports the proposed rulemaking. Thank you.
Thank you, Ms. Bennett. Thea Beckett, are you with us today? If you're on the phone, please unmute yourself. Okay, we'll move down to the next three. Judith Stanley, Carter Beckett, and Jeff Carver. Judith, are you with us today? Judith? Okay, we'll move down to the next one. Again, we'll call all of these things tomorrow morning just to give people ample opportunities. Carter Beckett. Mr. Beckett, are you here? Okay, we'll move to the next. John Carver. Mr. Carver, are you here?
Yeah, I'm here. I would
Please
just like,
state your name and affiliation. And you're
6
showing
million
up on the screen
climate change
as
deaths.
Nina Rosella. Is this Mr. Carver speaking? Mr. Carver, are you there? Mr. Carver?
We thought that we should.
You keep cutting out. Mr. Carver, are you
6
there?
million dead, according to the WHO, due to fossil fuel extraction or due to greenhouse gases. The leading cause of greenhouse gases is fossil fuel extraction. New Mexico is currently producing about over 40% of the greenhouse gases that the U.S. produces, and the U.S. under this president is now the world leading greenhouse gas producer. Greenhouse gases destroy the environment and they destroy people's lives. Vacuum is incompatible with human health.
The recorder cannot pick up what you're saying when you speak so fast. If you could slow down, please.
6 million
The recorder can pick up your information.
6 million climate change deaths, according to the WHO. Fossil fuel extraction and production produces more climate change deaths than anything else in the world. The U.S. produces more greenhouse gases than any country in the world. New Mexico produces over 40% of those greenhouse gases. These greenhouse gases are leading to the deaths of people, over 6 million. When 6 million died in Germany in World War II, the idea was that we should do something about it. Nobody's doing anything about these climate deaths. These climate deaths are also racist and white supremacist because the people who are dying are poor people and people of color and native people. The fossil fuel extraction industry continues the native genocide in this country. Let me repeat that. The fossil fuel extraction industry continues the native genocide in this country. Therefore, all fossil fuel extractors are ipso facto white supremacists and racists. Those aren't hard dots to connect. 6 million dead, nobody's being held accountable, and our government says she's an advocate for the fossil fuel industry. As has been pointed out, her response to COVID-19 and her response to climate change deaths are quite different. This is an enormous act of hypocrisy on the part of our governor, and I believe she's being driven by Secretary James Kinney, who is a racist white supremacist from Pennsylvania, who helped frack up that state severely. So we need to get rid of Kinney. He's got to go. This commission doing anything about produced water has to stop. This is a farce. Produced water kills people. It will kill our kids. It will kill your grandchildren. It will kill your children. It's threatening my son's life right now because the science says that human beings and animals are going extinct at an enormous rate. Obviously, this commission doesn't care about those animal lives, and they don't care about black or brown bodies, and they won't take their genes off our necks. People can't breathe when fracking happens. People die because of fracking. 6 million now, according to the WHO, the World Health Organization. That is not some schlubby organization. Those people do science and they know what they're talking about. This commission needs to do science and it needs to reject these ridiculous rules. There should be no produced water in Mexico. It is poisoned water and you're killing people. You sitting there right now are complicit with the fossil fuel deaths of people. To the degree that you're playing out this farce, you are complicit with fossil fuel deaths all over the world. You are murderers, second-degree murderers, murderers by neglect, murderers by willful ignorance of the science. Ban fracking now. We need to stop climate change. We need to do that by stopping the fossil fuel industry. It's a dead, tired, filthy, sexy, secretive, slimy industry, and it needs to be put to death. We need to kill it before it kills the rest of us, before it kills my kid. You're killing my kid, Adrian. You're killing my kid, Roger. You're killing my kids by sitting there in this meeting and pretending like this is real. You're killing everybody. You're a murderer, okay? I'll end my comment now. Respect these rules and stop produced water. It's racist, it's white supremacist, and when you participate, you're racist. racist and you're white supremacist too. It's a continuation of native genocide sitting there on land that was never yours to begin with and was never ceded to you. This government, of course. It's based on native genocide. It's based on racism, institutionalized racism, and it needs to stop. Produced water has to stop. 6 million dead should mean something to you. 6 million dead. I see 6 million dead people due to the big oil and gas industry. I see dead people because of those industries, and they have to stop killing us. They have to stop extincting my kid. They have to stop extincting my grandkids. Okay? Stop it. Stop fracking now. Ban fracking now and stop being such bozos. You're like our stupid president. You're institutional racists, and you're complicit with a system that kills children. You personally. And everybody who's on this call who's not doing anything to ban fracking is part of the problem. They're helping out. They're helping kill people. 6 million dead. 6 million. See you later.
I also want to note for the record that Vita Rosella, and it's unclear. This time was for John Carver. The name on the screen says Vita
Rosella is
John Carver was expelled from this hearing earlier. And it has walked
I came back as Vita Rosella.
Thank you. You will now be excluded from the hearing, as you were excluded earlier, and we gave you multiple warnings. All right, the next 3 people on the list, I think we're going to go through 3 more, and then we'll break for lunch. And we'll note at that time when we break for lunch and when we will come back for lunch. And we will continue public comment when we return. But the next 3, Erica Bell Benedetti, Mary, and Justin Nobel. Erica Bell Benedetti, are you with us today? Miss Benedetti, are you with us? Thank you. We will call your name again tomorrow. Mary Kopinen, are you with us today? Ms. Kopinen, are you with us today?
Yes, I am.
All right, thank you. You have 5 minutes. Please state your name and any affiliations that you may have.
Oh, yes, thank you very much. I hope that we're allowed to do more than, well, thank you for allowing us to speak. I am looking at my map of the Rio Grande, and I think it's absolutely criminal that this is even brought up. You are a poor reflection, I'm very sorry to say, of our state of America, except you're embodying it perfectly. I'd like to give my remaining time again to Marielle. Thank you.
Okay, thank you. Justin Nobel, are you with us today?
Yes, I'm with you. Can you all hear me?
We can, thank you. Please state your name, affiliation, if there is one, and you have 5 minutes.
Okay, excellent. Good day. My name is Justin Noble. I have a dual master's degree in Earth and Environmental Science and Journalism, write on issues of science and the environment for U.S. magazines and investigative sites. Recently published a lengthy story for Rolling Stone magazine entitled America's Radioactive Secret about the radioactivity brought to the surface in oil and gas production and the many different pathways of contamination posed to the industry's workers, public and communities, and the environment. And I'm presently writing a book on this topic for Simon & Schuster. Ladies and gentlemen, it is pathetic that a journalist for a music magazine has been forced to break news America's oil and gas industry has known for decades. I quote, "Almost all materials of interest and use to the petroleum industry contain measurable quantities of radionuclides that reside finally in process equipment, product streams, or waste. In addition, groundwater used for water flood and brine solutions from operating wells contain biologically significant quantities of radium-226 and radon-222. These lines do not come from a research scientist at some Eastern university far removed from the oil patch. They do not come from the newsletter of some environmental action group, which may have a vested interest. These lines, in fact, come from a 1982 report of the Department of Medicine and Biology of the American Petroleum Institute. The report goes on to describe the radioactivity risks of the industry's waste. Quote, "Radium-226 is a potent source of radiation exposure, both internal and external. Radon-222 and its daughters cause the most severe impact to public health." The 1982 American Petroleum Institute report also invalidates the department's plan, as laid out in this proposed rule, to, quote, "encourage the recycling or reuse of produced water." Again, I quote from the American Petroleum Institute report, "Any control methodology proposed for radioactive materials must recognize the fact that radioactivity cannot be modified or made inert by chemical means. Decay to daughter products cannot be guaranteed to reduce the hazard." And just a few lines later, to remove radioactivity is merely transforming, quote, "a very dilute source of radioactive materials into a very concentrated source of radioactivity." So the proposed rule encouraging the treatment of this complex radioactive waste stream is nothing more than a free pass for industry to contaminate uninformed and inappropriately protected oil and gas workers, i.e. human beings, i.e. men, women, mothers, and fathers. And members of the department and commission, this one damning 1982 American Petroleum Institute paper is not alone. The idea that this issue is not a big problem or only a problem in the Marcellus shale play or back east is not just absurd. This ignorance puts the lives and safety of the workers and communities of the great state of New Mexico in peril. To prove this point, from a 63-page report produced in 1991 by the esteemed petroleum geologist John B. Comer of the Bureau of Economic Geology at the University of Texas, Austin, quote, "The Upper Devonian Woodford Formation is an organic-rich petroleum source rock that extends through West Texas and southeastern New Mexico and is very radioactive. Your rule makes no mention of this highly dangerous radioactivity, and it makes no mention of how you will protect the workers and residents of New Mexico from contamination. While the present New Mexico regulatory agencies have unfortunately taken scant interest in assessing and monitoring radioactive elements inevitable in the oil and gas industry's waste stream, such as radium, a bone-seeking human carcinogen known to have pronounced effects in children with swiftly growing bones, that does not mean your workers and residents cannot be affected by radium or any of the other well-known carcinogenic radioactive elements common to oil and gas waste. Quote, "There is no threshold of exposure below which low levels of ionizing radiation can be demonstrated to be harmless. Health risks, particularly the development of solid cancers in organs, rise proportionally with exposure." This from Harvard epidemiologist and chair of the National Academy of Sciences 2006 Biologic Effects of Ionizing Radiation report. Just because you do not believe the science or know the science or care to read a few research papers to understand the science does not mean the science doesn't exist, and does not mean the science won't eventually lead to lethal cancers in the workers and residents you are charged with protection. I sincerely hope the Department and Commission reconsiders this science-starved rule and makes a complete about-face on this topic. Either way, your paltry regulations have already enabled an easily traceable trail of contamination to be spilled across the great state of New Mexico and quite literally deposited in the bones and bodies of its people. Radium, again, as anyone in the medical community knows, is a bone seeker, mistaken for calcium, incorporated into our skeleton. And as cases during the 1980s from Mississippi and Louisiana oil patches have shown, these exposures may not just lead to cancer and disease in workers. Oil and gas workers bring contamination home on their clothes and bodies to their family members. As Dr. Harrison Martland, one of the great founders of the field of occupational radiation safety, lays out in his seminal 1931 paper in the American Journal of Cancer on the Radium Girls,
please finish up. We've hit the 5-minute mark. We'll give you a
The
short time to finish.
Okay, just 20 more seconds. This bombardment of radioactivity these women experience will last for an indefinite period. For instance, in the year 3491, the skeleton will still be giving off 185,000 alpha particles per second, end quote. So in conclusion, the contamination you enable to be spread, spilled, and sloppily treated across this land of enchantment is not going anywhere. This carelessness will be recorded indefinitely on the land and in the bodies of its people. And myself and my colleagues, the scientific experts, and the many, many attorneys of the future will find these victims, and we will expose the catastrophe that has been unleashed. Thank you very much.
Thank you. As I mentioned, we'll do 3 people. The next is Miss Joan Brown. Joan Brown, are you with us today? I believe you said at the beginning you may have some issues with the landline. Miss Joan Brown, are you with us today? Okay, Elaine Chimino, are you with us today? Elaine Chimino, are you here today? Okay, we'll move to the next. Patrice Muchnick, are you with us today? Patrice Muchnick, I apologize if I'm messing up your name. Okay. Artissimo Romero, are you with us today?
Hello, my name is Artemisio Romero. I'm with you today.
Great. You have 5 minutes. Will you please state your name and affiliation? And then you can proceed.
Hello, my name is Artemisio Romero. I'm affiliated with Yucca Action, Youth United for Climate Crisis Action. I'd like to begin. New Mexico is a poor state. We are also a majority minority state. We are a state that both by class and race exists at the bottom of this country's capitalist and white supremacist hierarchies. To make that simple, we are expendable. Because of this, my home state has filled 2 consistent roles. We have served as a post for large corporations to take resources at a cheap price. As a place to test unsafe technologies on a primarily brown and indigenous population. Both of these roles are why a word or a lie like produced water exists. It's a product of the first role, resource extraction. This state houses and based in the cheapest oil field in the world. And I can promise you, the oil industry that desecrates that land is heavily underregulated. So much so that we don't even know the chemicals they use in combination with our fresh water. Which brings me to that second role. The atomic bomb and with the storage of dangerous uranium waste near impacted communities. We're talking about a substance whose identified ingredients include carcinogenic or the stands for state undaunted. I don't believe it's the first state testing the harms of fracking waste is one of the brownest. Conscious decision or not, it's consistent with the characteristic of supremacism. The reason so many lobbyists and officials like the ones present here today wanted to begin the rulemaking is because it allows them to exploit in both of those 2 ways simultaneously. At the same time, they enable the dangerous underregulated fracking industry. They can also test the radioactive properties of fracking waste on an innocent population. So, members of the Oil Conservation Commission, I came here to tell you with all undue respect, we refuse to be your guinea pigs. I would now like to read the statement that Yucca has prepared as a letter of demands. Okay, thank you.
If you take your camera off, we might be able to hear you uninterrupted.
Yeah, it looks like you have low bandwidth. It may be
The
helpful
youth of
to
Yucca stand
turn
with
your camera off. Are you still with us, sir?
I'm still with you. I believe somehow I was muted. At what point did I cut off, man? Okay, then I will just continue from the beginning. The youth of Yucca stands with 42 tribal government representatives, groups, and businesses representing the indigenous and minority voices across New Mexico, Texas, Colorado, and Arizona, who filed a joint letter.
Sorry, sir. Sir,
Calling on
this is
Mexico's
Irene.
oil
Please don't interrupt
Yes?
him as he speaks.
This is Irene, the court reporter. Could I ask him to slow down a little bit, please?
Yes,
Thank
ma'am.
you.
Sorry about that.
Thank you. Yucca is publicly demanding that the Oil Conservation Commission suspend all current. There has been no meaningful outreach or engagement with the public or impacted communities. As a result, we recognize the state's authority in these proceedings as illegitimate. We demand future rulemaking by the OCT acknowledge the untreatable nature of produced water and protect our environment and citizens from its associated dangers. The health risks of New Mexicans cannot be forfeited so that the oil industry can offload the hazardous materials they create. A modification of fracking waste will serve only to prolong the racist and intergenerational violence of fracking. We are standing against any and all efforts to bail out the industry and expand extraction-based economies. We are facing budget austerity measures because we've relied on an industry that is fundamentally unsustainable and is based in killing our people, poisoning our land, and destroying our planet. It's time to wake up and hold industry accountable. We demand research and investment in a just transition and a moratorium on fracking within the state of New Mexico. To put it simply, members of the commission, we demand justice. Thank you for your time. I yield.
Thank you, sir. So we are now going to take a break. It is 12:08. We will come back at 1 o'clock. We will resume the meeting. The meeting will stay live. We're not going to turn it off, but we will turn off the video and mute it. So please join us back here at 1 o'clock. We will continue with public comment. And the next three in order are Brittany Fallon, Norman R. Norville, and Susan Selvin. So those are the next three that we will begin with at 1 o'clock. So please join us back at that time. Again, just a reminder, you have until 3 o'clock today. If you were not able to register to speak today, you have till 3 o'clock today to register to speak tomorrow. Thank you, and we will get going again at approximately 1 o'clock.
Chairwoman?
Yes.
This is Brittany Fallon. I am not available at 1 o'clock. May I speak later in the afternoon?
We can put you at the end of the list.
That's perfect. Thank you.
Okay, so in that case, it will be Norman R. Norville, Susan Selvin, and Lynn Allen. Those will be the three who begin at 1 o'clock. All right, thank you, everybody. We'll continue again in 15
mute.
Good afternoon, everybody. I hope you had a lovely lunch. It is 1:02 on Thursday, July 30th, and we will resume the hearing of the Oil Conservation Commission. We ended on public comment, and we will continue now with public comment. Picking back up on the list, the three next individuals are Norman R. Norville, Susan Selvin, and Lynn Allen. Norman, are you with us today? Norman Norville, are you here today? Okay. Susan Selvin, are you here today? Yeah. Susan, we see your name on the WebEx. It looks like you're unmuted. Are you able to speak at the moment? If you're speaking, we cannot hear you. Okay, we will call your name again tomorrow. Lynn Allen. Lynn Allen. Okay. We'll go to the next three names. Just a reminder again, we'll call the names who were not responsive today again tomorrow. Clifton Bain, Melissa Troutman, and Ian Tafoya are the next three names. Clifton, are you with us? Clifton Bain? Okay. Melissa Troutman.
Hello, can you hear me?
Yes, we can, Ms. Troutman. You have 5 minutes. Please identify if you're affiliated with any organization, and then please proceed.
Sure, thank you. My name is Melissa Troutman. I'm a research and policy analyst at EarthWorks. It's dedicated to protecting communities from the impacts of oil and gas industry operations. Includes documentation of the industry's waste streams, which have here in Pennsylvania, where I'm from, and where I'm currently a frontline.
It may be easier if you turn your video off. You're
I'm
kind
sorry.
of glitchy. You're kind of glitching. Maybe sometimes when you turn the video off, sometimes it picks up better.
All right, my video is off. Is this better?
Yeah, that's much better.
Oh, good. All right, let me fast forward a little bit for the sake of time lost here. I want to acknowledge that I'm speaking to you from stolen Seneca land, and that the native people of Turtle Island are the original caretakers of this land and lived in harmony with nature for thousands of years. I also want to acknowledge that this body, the OCC, like others, is an agency that derives its position from a colonial government that claims power over stolen land. It is not the legitimate authority of the land. It's been created pollution permitted by the government of New Mexico must be stopped. And it's with this in mind that I testify today. As we all know, the oil and gas is exempt from federal hazardous waste law, despite the fact that various oil and gas waste streams exhibit physical characteristics of hazardous waste. The exemption, the RECRA exemption, alongside the Halliburton loophole, all common sense and scientific evidence by allowing industry to keep chemical additives, including carcinogens, a secret. Commissioners here cannot change the federal law, but you are in to protect New Mexico in spite of it. But you're not with this proposed rule. If you were, the following would be true. Hazardous oil and gas wastes would be characterized inside the oil and handled using hazardous waste criteria and regulations. The full disclosure of all additives used in oil and gas operations and their concentrations available. And of course, the use of untreated or treated produced water outside of the oil field would be discouraged by this rule, not presumed as a potential inevitability. And of course, comprehensive testing of produced water for all additives, which would be required to be disclosed, would be required prior to wastewater leaving a well site. There's been major mistakes that have happened in Pennsylvania that can be avoided in New Mexico that I'd like to share with you. One is that in New Mexico, in Pennsylvania, the discharge of treated produced water, that is produced water treated with best available technology, has created radioactive riverbeds here. Duke University published a study in January 2018 that found cancer-causing radium 650 times higher in the river sediments where treated oil and gas wastewater was discharged. Another problem we have is road spreading. In May 2018, University the spread of oil and gas wastewater on roads indicated high levels of radium. Radium is a carcinogen. Radium-226 has a half-life of 1,600 years. So here's what's happening. Treated or untested produced water from the industry is allowed to be discharged in Pennsylvania, and when it's treated, it's according to drinking water standards, which means it's a small amount. Is that it accumulates over time. So even if you put out tiny amounts per liter, so 5 picocuries per liter, that stays there and accumulates over time because it has a half-life of 6 years, which means that it turns the riverbeds radioactive. Finally, frontline residents like myself and the public are denied access to critical health and safety data here in Pennsylvania regarding the constituency and concentration of toxins in this wastewater as it's being transported through our communities in front of our homes. The lab analyses that are required have been withheld by Pennsylvania Department of Environmental Protection. The company's transporting wastewater over top of my family's water supply every single day is required by our state to test it, but they are required to give us that information, and in fact, requests are denied. Now, it has been Earthworks' hope. Sure, I'm almost done.
5 minutes will give you a little bit of time to finish up, though.
Sure, thank you. Earthworks' hope engages a stakeholder throughout the rulemaking processes regarding produced water in New Mexico, and our hope was that this would become a best-in-the-nation policy for managing produced water. But unfortunately, that's not happening. New York State legislators last week passed the nation's first bill to close the hazardous waste hole for the industry. So New Mexico, you got some catching up to do. Thank you.
Thank you, Ms. Troutman. Ian Tafoya,
Hello, can you hear me?
we can. Please state your name, any sort of affiliation you may have, and then you have 5 minutes.
My name is Ian Thomas Tafoya, and I am from Colorado. I am the co-chair of the Colorado Latino Forum, which is a nonprofit that works to improve the lives of Latinas and Latinos across the state of Colorado. Currently, of our 11 members, we've all run for office, and several of them are currently office holders. I also am the organizer of Colorado for Green Latinos, a national environmental justice and environmental organization, a network of conservationists and environmentalists that get involved in things that affect Indigenous and Latino public health. I'm here today to express my supreme disappointment that this meeting has gone so awry. I myself worked as the secretary of a city council, the Denver City Council. Not posting documents, I believe, is enough reason to postpone this type of hearing. But I really want to talk about why I think this is such a bad idea. I hold a water certificate from Metropolitan State, the World One Water Center, sponsored by the state of Colorado. And we're not thinking holistically about the long-term harms that spreading radioactive things that are meant to be in the ground, out on top of the ground for them to impact us all. I have deep concern that you're going to set a precedent that will be leveraged against my state and my community. We know these oil and gas wells and rigs have not treated employees well, have not treated communities well. In fact, they constructed wells across the street from an elementary school in my community. They spill benzene and pollute the air. And now, while they're faltering in their economics, places like New Mexico choose to prop up their industry by allowing them to now sell toxic water and call it life. We talk a lot about black snakes and oil and gas and what it means. Well, I had a chance to visit Chaco Canyon for the solstice. And I can tell you is there's a gray snake of road construction and an invisible snake of toxic pollution that moves through the air like water and through our water and into our bodies. These are broken promises. These are continuation of broken treaties. These businesses will be bankrupt and they will leave the legacy pollution to clean up by you or to be bared by frontline communities for another generations or longer. I ask you, the Colorado Latino Forum asks you, Green Latinos Colorado and our members, many who live and have family in New Mexico, ask you to think twice. This is your opportunity to protect water. Please do that. Thank you.
Thank you, Ian. Okay, so I'll go through the next 3, but prior to doing that, it looks like on the chat people are asking about what the kind of order of operations is. As I mentioned earlier, we're going to continue to go through the public comment list that we received prior to 5 p.m. yesterday. There are a total of 45. We are about halfway through. And so I expect that public comment will, continue to take the next couple hours. Following that, witnesses will be presented by the parties if they have them. But some of that will just depend on how long public comment takes. We cannot provide specific times because we do not know how long public comment will continue to take. It could be a variable amount of time. So that's the order of operations. The next 3 individuals are Walter Tomas, Gabriela Marks, and Mary Ogle. Walter Tomas, are you with us today? Walter Tomas, are you with us? Okay. Gabriela Marks. Ms. Marks, are you with us today? Okay. Mary Ogle. You're showing up on the WebEx participant list If you're trying to speak, Ms. Ogle, we cannot hear you. Ms. Ogle, are you able to speak at the moment? Okay, we'll move down to the next list of participants. The next three are Madeline Carey, Jean Harbaugh, Oliver Hillenkamp. Madeline Carey. Madeline Carey. Jean Harbaugh. Jean Harbaugh. Oliver Hillenkamp.
Hello, yes, I am here. Can you hear me?
Yes, we can.
Okay, awesome.
Is this Oliver?
Yeah, so my name is Oliver Hillenkamp. I just want to say that I think that we need to take bold action in our state to address the climactic and existential threats that fracking poses to New Mexicans. And I believe that from expert people that have explained this to me, my understanding is that produced water is too toxic to actually treat effectively, and that the best way to reduce fracking waste is to actually reduce fracking in the first place. And the proposed rules that we are discussing were prepared too quickly and were not really prepared with meaningful engagement with the public or with the impacted communities of of the toxic waste and the water, produced water. And we cannot allow the fracking industry to dispose of this wastewater in frontline communities and lands. And I really just think we need to take a stand against this and not just allow the industry to steamroll over us. And that's pretty much all I have.
Thank you, Mr. Hillenkamp. Okay, I'll go through the next three. Jeffrey Haas, Pamela Marshall, Joyce Bogosian. Jeffrey, are you with us?
Madam Commissioner, this is Mariel Nassi for New Energy Economy. Both, there are two people, that one who you called before the break, Norman Norval, and Jeffrey Haas, both contacted me and are no longer able to accommodate this scheduling. And I have Norman Norval's statement, which I believe he also wrote to Ms. Florine Davidson. And so I asked that be included as part of the record. And Mr. Haas indicated that he would also send his written statement into Ms. Florine Davidson as well. And I'm asking that they be included because they were able to meet these time deadlines.
Okay. Yeah, I think as Mr. Lozano laid out, we will, kind of take the remaining exhibits that we collected today and enter them into the record tomorrow. So we'll go through that process of gathering any more written comments, et cetera, that have come. And then we will call everybody who did not respond today but was on the list again tomorrow. So if by chance they're available tomorrow, they'll have another opportunity.
Thank you kindly. And I just want to say that you called Madeline Carrie just a few minutes ago, and she is available according to the chat. Thank you very kindly.
Okay, Madeline, Carrie, are you with us? If so,
Yes, I am.
please go ahead. State any affiliation you have, and then you have 5 minutes to address the commission.
My name is Madeline Carey. I'm not affiliated with anyone today. I'm representing myself, although I am employed by Wild Earth Guardians. I'm here to speak against the proposed rules. I have grave concerns. Specifically, as a horse owner, I'm concerned about the impact that these rules could have on the production of forage for New Mexico's horse and livestock industry. There is a well-documented study of hay and pasture grown with frack water causing a high level, over 50% of life-ending mutations in young foals whose mothers grazed on hay grown with frack water while they were pregnant. And I'm concerned that a large portion of the hay grown in New Mexico is irrigated with water. It's flood irrigated, it's not sprinkler irrigated, and that there's nothing to protect people like me, that there's no consultation with the New Mexico Department of Agriculture, there's nothing proposed to safeguard other industries against the potential harm caused by this rule. I also have a lot of concerns. I go to a ton of public meetings for my job. I engage other people who come to public meetings. I think the transparency process around this meeting was particularly horrendous. We've all had to be doing stuff digitally for months now. And I was on earlier, I had to step away for a call. A lot of the concerns around what's going to happen with the chat, if it's going to be resolved. I found the answers to be really inappropriate. It's not a surprise that these meetings are occurring digitally. This is the new normal. We've had months to prepare. I'm really, frankly, disappointed in this agency and this administration in doing that. And I really think this meeting should have been canceled, and that there has not been enough done to ensure that there can be proper public engagement on this. And just back to my first point, I think, you know, it's easy to say, oh, we're recycling water, we're doing this and that. There's been studies done. But there hasn't been a study done on the impact of children who eat Papa John's pizza, whose mozzarella is produced in Las Cruces, New Mexico, or southern New Mexico, by cows who are fed with alfalfa that is grown with produced water. And that is an example of the type of cascading effects that this rulemaking process could have. And I frankly don't see this agency showing interest or initiative in trying to address those things, rather saying, oh, we have done some science and there are some examples of some problems being mitigated, rather than saying, what are the real health and human and animal safety impacts that could happen if we go forward with the rulemaking. Thank you.
Thank you, Ms. Carey. Okay, the next three are Pamela Marshall, Joyce Bogosian, and Sandra Wheeler. Do we have Pamela Marshall with us today? Pamela Marshall? Joyce Bogosian? Ms. Bogosian, it looks like you're on the WebEx. If you're speaking, we cannot hear you. Ms. Bogosian, are you there? Okay, Sandra Wheeler? Sandra Wheeler? Okay, I will go to the next three names. Barbara Cole, Nicholas King, and Yang Toledo. Barbara Cole, Barbara Cole, Nicholas King, Nicholas King, Yang Toledo.
Can you guys hear me?
We can. Please state your name and any affiliations if you have any, and you'll have 5 minutes to speak.
Okay, thank you. Hello, Madam Chair and members of the Commission. Good afternoon. My name is Yang. I come from the Diné Nations in Farmington, New Mexico. I am a first-generation graduate and a steering committee member of Youth United for Climate Crisis Action. I am a spokesperson representing my Indigenous people on behalf of the Navajo Nation. And I want to let you know how my people are systemically targeted in this corruption of unsafe and unjust economic development for resources to provide for this country and this state. We must put an end to this genocide of Indigenous people for resources. Produced water will only increase our environmental disasters around the four corners. My hometown, Farmington, is heavily polluted by the Gold King mine spill that happened in 2015. We are unable to farm and maintain a healthy lifestyle with the current state of iron and aluminum in our rivers currently. Allowing produced water into New Mexican clean water is poisoning our people. If the oil and gas industries don't know where to put the produced water, stop fracking and ban the extraction of Indigenous homelands and lives. Farmington is home to 2 coal plants, which is one of the most extracted, impacted areas in New Mexico. This risky approach to release produced water into New Mexico's water resources is supporting the big corrupt oil and gas companies to kill our people by poisoning our water sources and profiting from it. The reservations are where fracking tactics are implemented, and oil and gas barrels reside all over, and there is no adequate food, shelter, water, or medicine to care for my people. The air pollution that surrounds causes health-related problems and now makes our Indigenous relatives more likely to die from COVID-19. My elders that live on the reservation do not have access to clean, running water or electricity. We have to live through these environmental effects that our elected officials decide. Have you elected officials gone out to the Navajo reservation and inhaled the toxic chemicals that kills my people every single year? Have you drank from our water source to taste the chemicals? And have you bathed in toxic water only to have skin rashes from the water source? OCD's request to recycle produced water will only kill our people and environment. We, the youth, have to shine a light on the inequality the Indigenous people and colored people have been facing for multiple centuries. Indigenous communities across the United States face the dangerous atrocities and consequences of pollution from the pollution of the politicians' mistakes and failures. My ancestors have perished without the necessities of healthcare and safety responders that we have a dangerous economy infrastructure. The COVID virus is just a piece of the climate crisis problem, and we need to understand these problems will not go away. It will continue to get worse if we do not honor the traditional medicines from the earth or knowledge of the Indigenous people. In these desperate times of humanity, we need to make adequate transitions to justice, and this must require frontline communities to have a seat at the environmental decisions being made, such as this produced water hearing. You will not be there when the toxic waste kills your family, our family. Those being affected by extractive fossil fuel epidemics are rapidly losing family members. Now the youth are not taking a stand. Now we're taking a stand against the generational genocide of our people. We are all throughout the state on different reservations in mobilization efforts to change public policy to help our people benefit from the transition of the renewable energy economy. We only have a decade or less to drastically reduce our carbon emissions or face the existential threat of climate change. Before this crisis, many people faced drought, water scarcity, and pollution in their homelands, making them more vulnerable to catch the virus. These impacts hit our land-based communities the hardest, and the science is clear and the facts are clear. You've heard statistics all day, but we have only a few years left to rapidly shift to a carbon-neutral economy, to a sustainable transition. The extraction of fossil fuels in New Mexico poses a threat to our future, and we recognize that our state is ripe with potential for renewable resources. New Mexico can be a leader in the necessary shift to a carbon-neutral economy with the leadership of our elected officials. The climate crisis will not go away in the blink of an eye.
We'll let you continue and wrap up for a short period, but you take your 5 minutes, ma'am.
Okay, I'm almost done.
Thanks.
Thank you. Just as the coronavirus will not be treated until we take precautionary actions to prevent the spread of and find a vaccine solution. Oil spills on the land, polluted water systems in New Mexico have got to be ended and prevented from happening right now. If we took the necessary actions of switching to renewable energy sources 50 years ago, communities wouldn't be facing food or water scarcities in New Mexico. In the Four Corners area, I have witnessed the tremendous change that has benefited the earth, that has not benefited the earth, people, or the economy. I witnessed chemical pollution kill the land, people, and water. The profit that the state makes does not make a change in New Mexico communities, economy, or environment. These resources will run out and create catastrophic environmental disasters for all humanity. And the Navajo Nation is already an example. Throughout the United States, we see reservations, people dying because of the environmental crisis and viruses, and no access to clean water. And we, as New Mexico, must find a new sustainable solution to help our people and the environment before it's too late. Please support a sustainable, clean environment for everyone in the state. We ask that the committee deny the proposal of the OCD's plan and reconsider a sustainable, clean proposal for the produced water, and stop fracking. We must make big sacrifices for the environment and not our wealth.
Can you please
Thank
wrap
you.
it up? Thanks. All right, we have the next 3 participants. Sharon Argenbright, Grietti Laga, Patricia Shelley. Do we have Sharon Argenbright with us? Sharon Argenbright? Grietti Laga?
Hi, can you hear me?
Yes, we can. Please state your name and affiliation.
Okay. So let me know when I cut up like so many other people don't come through fully. Is that okay?
Yep.
Great, thank you. So my name is Grietje Laga. I'm a resident of the Apache Creek watershed, which is part of the Upper Rio Grande bioregion. Thank you for the opportunity to speak today. First, it's important to me that you know that I'm a mother of 2, an educator to many, as well as a mental health worker, more specifically in the realm of youth suicide prevention. And if you want to affiliate me with an organization, I know myself to be connected with Yucca, New Energy Economy, and Retake Our Democracy. One moment. because I've been rewriting some words here. I'm not a scientist, nor am I good with long papers and documents that describe these type of regulations, rules, and adjustments. So you won't hear numbers nor stats or references to studies from me. I'm much more comfortable with realms of intuition and common sense, which is not necessarily a basis of knowledge and awareness in our current white supremacist society. However, at the risk of being ridiculed, I will speak nonetheless. And I come from a place of deep care, of intense love for humans and non-humans alike. And from that place, I just need to say that I'm absolutely appalled at the proposed regulations, which would make it easier for the oil and gas industry to transport and dump its toxic waste. One doesn't need to know numbers and stats to understand how dangerous and exceedingly reckless these proposals are. Just ask any child who plays outside, who loves jumping in water puddles, who eats dirt once in a while. Ask any Native youth, just like we heard from Yang Toledo earlier. It is clear to me that the industry, the oil and gas industry, is playing with our health, my kids' health, my neighbor's health, your health, and as importantly, if not more importantly, with the health and the well-being of the land. And so please, please suspend the rulemaking. One more moment here, because I think there ought to be a pre-rulemaking engagement with the public, one that is accessible and easy to join in, unlike this particular format. Easy to join in, especially for directly impacted communities. And furthermore, and maybe even more important to me, I urge you to start naming this so-called produced water for what it truly is. It is toxic, meaning it kills. It kills because of what this water contains: radioactive materials, heavy metals, other contaminants. And so please do no longer use a euphemism that hides the truth. That is just not okay. And I'm getting really emotional about this. So I will end with some of the final words of John Lewis. His words were published in the New York Times today, only a couple sentences. So, quote, "Now it is your turn to let freedom ring," unquote. And at the very end, he says, quote, "I say to you, walk with the wind, brothers and sisters, and let the spirit of peace and the power of everlasting love be your guide," unquote. So commissioners, please do your part to free these lands, which we call home. Do your part to free these lands of the indoctrination and continued exploitation by the gas and oil industry. And may the winds, as well as everlasting love, inform all your decision making. Thank you very much.
Thank you. I think we're going to take a 5-minute break. Our system here is trying to shut down. We are going to try to keep that from happening. On the chance that you get kicked off of here, please just log right back on, and we will get back started in a couple minutes. Again, we're going to take at least a 5-minute break. We're going to attempt to keep this from shutting down. If it does and you get kicked off, please just call back in using the same information you logged in with this morning. Thank you.
Was it WebEx or was it the whole computer that wasn't flipped wrong? WebEx? Okay.
You may not.
Oh.
Like, it's still been live.
It's like Okay, so I think we're gonna have to close it. Can we close it and restart it?
Yeah, I guess we have to.
Yeah, because it's like.
Yeah. Did you listen? I heard something. That's good.
Okay, thank you, everybody. We will get the meeting started again. It is 1:47. Okay, the next three, Patricia Shealy, Seneca Johnson, and Denton McCullough. Patricia Shealy, are you with us today?
This is Patricia Shealy.
Great,
Can you hear
me?
me?
Yes.
Thank you.
Please proceed.
My name is Patricia Shealy, and I am a resident of Gallup, New Mexico. I moved to New Mexico in 1993. I grew up in Ohio. I love the land of enchantment. Its open spaces, its rocks, its vegetation, and its people. I am concerned about its water supply. We are seeing higher and higher temperatures and less rain. Though I grow native drought-resistant plants in my backyard, some are dying. My faith tradition compels me to speak today. We need water for the life of our people, for the life of the animals, and for the life of the plants. I have three main concerns: depletion of freshwater resources, protection of our freshwater resources, and the toxicity of produced water and its effect on human, animal, and plant life. Produced water, the fluid that comes back up to the surface in the fracking process, should be used only in the fracking process. My understanding would be that more chemicals would be added. This is a better solution than storing it in natural underground wells. Fracking uses a lot of water, which is in limited supply. The reuse of produced water for fracking would save our water and possibly prevent contamination from underground storage. Produced water is toxic. It can even contain uranium. Here in McKinley County, we understand the effect of uranium contamination and the difficulty to get it cleaned up. Produced water can easily contaminate the surface water and land through spills. Right now, we have inadequate information regarding spills. Knowledge is essential for making the best decisions. We need information on what is in the produced water. We need to know how many spills are occurring, how large they are, where they occur, and what happens after they occur. This information needs to be obtained in a timely manner. The present system of the industry self-reporting is not sufficient without adequate oversight. We need to determine how many people are required to carry out this work. These issues could have been discussed and resolved in a satisfactory manner if stakeholders were involved in creating these regulations. Since they were not, I ask that the rules be strengthened to protect the public health, the environment, and our freshwater resources. Thank you.
Thank you. Okay. The next individual is Seneca Johnson. Are you with us today? It looks like Ms. Johnson, you're pointing up.
Just a little bit.
Hi, I think we can hear you, Ms. Johnson.
SENCO.
Ms. Johnson? Ms. Johnson?
Okay, you can open. So this is your new prescription, and this right there is what's in your glasses. Oh, that's so different. Oh my God.
Seneca Johnson.
Mostly the left side. The right eye changed too, but the left side is
Seneca Johnson.
Which of those four vertical lines appears
Come back to her at the end. Feeling Denton McCullough. Denton. Okay. The next three. Joshua Damian Martinez, Ruth Striegel, and Noah Tempest Paris. Do we have Mr. Damian Martinez? Mr. Damian Martinez? Ruth Striegel? Ruth Striegel? Noah Tempest Paris?
Hi, before I speak, I was in contact with Seneca and she asked me and others to let her know when she's up. We're apparently having trouble reaching her. Could she be put to the bottom of the list?
Yeah, or if you want to finish yours and then her go directly after, if that's easy, that would be amenable.
Well, contact her.
Would it be easier for her to go at the bottom of the list?
I think so.
Okay, yeah, no problem. Okay, please state your name, any affiliations you may have, and you have 5 minutes.
Yes, my name is Noah Tomas Paris. I attend college here in New Mexico, and I would like to be representing myself, although I am a volunteer for Youth United for Climate Crisis Action. And first, I want to address the strange way that this hearing started, because it started as people who wanted to comment on the rulemaking process or on the proposed rules could be subject to cross-examination. And that on its own is incredibly confusing, because how does that even work when you're just trying to represent yourself? And I'm glad that you all unanimously decided to not make that part of the process after someone from Wild Earth Guardians, I believe, raised an objection. But it makes me wonder how and why it was put in as part of the process in the first place, and who exactly did it, since you all clearly unanimously agreed to take it out of the process. So I just want to mention that as part of the public record as something that's incredibly strange. And moving on to what I have prepared, I want to start with the very problem of it being called produced water in the first place. It doesn't really accurately describe what we're talking about. This is toxic fracking waste, and it's this toxic mixture of radioactive materials like radium, heavy metals, and chemicals that we're not even allowed to know about it because it's considered a trade secret and proprietary to the oil and gas industry. And so that on its own, should give people pause when considering this rule that refers to this waste as produced water. But the proposed rule would allow the oil and gas industry to discharge or otherwise dump the toxic fracking waste outside of oil and gas producing areas, and it explicitly implies that the Commission will at some point adopt rules that will allow the dumping of this fracking waste onto lands and into streams. And the NRDC released a report 8 years ago saying that this fracking waste is in fact incredibly toxic, and none of the tools we have for treating it or disposing of it are adequate to protect the public health and environment. And given that as recently as 2018, Pennsylvania decided to ban the spraying of this fracking fluid onto roadways because it was harming public health and the environment. And the fact that even today, the way that we dispose of fracking waste is to basically just dump it into these giant pools and let it evaporate shows that there doesn't seem to be, it hasn't been shown that there's an adequate way to treat this water, let alone have it be done at a mass scale, let alone have it be done in a cost-effective scale. So before we have a way of showing that this fracking waste can be treated in a way that keeps the environment and public safe, we are putting rules in place that allow the dumping of this fracking waste onto lands outside of the areas that produce this fracking waste water. And I mean, they're called sacrifice zones for a reason. It's because the materials that they produce are toxic and they have to be contained. And that alone is incredibly problematic. And I completely understand the position that New Mexico is in, because we need to figure out how to conserve our water and maintain our water as droughts get worse because of climate change, which fracking ironically contributes to. But it should be clear that the solution shouldn't be to try and let the industry dump outside of the oil and gas producing areas, but to put a moratorium on new fracking wells until we can get this problem sorted out, or if we decide that or until we can adequately conclude that the problem can't be fixed and we have to phase out fracking altogether.
Sir, you reached your 5 minutes. You can kind of wrap it up, but please try to wrap it up.
Okay. I'm going to end with the call to please delay the rulemaking process and implementing rules until a thorough and adequate review of the scientific data has been completed, because it has not been shown that that has been done. Thank you very much. And I digress.
Thank you, sir. Okay, I'll list the next three. Wendy Tissity, Liz Gold, Feline Romero. Wendy Tissity, are you joining us today? Wendy Tissity. Liz Gold. Liz Gold. Feline Romero. Elena Romero. So the three remaining we have are Brittany Fallon, and then it'll be Seneca Johnson, and then Valerie Gramillion. Okay, Brittany Fallon. Are you with us? Brittany Fallon? Okay. Seneca Johnson?
Hello, can you hear me?
Yes, we can. Please state your name, affiliation, and you have 5 minutes.
Okay, thank you so much. Hello, my name is Seneca Johnson. I'm from the Muskogee and Seminole Nations, and I'm a steering committee member of Youth United for Climate Crisis Action. So extractive industries have been pillaging our communities and putting our people at risk for decades, especially in Indigenous and vulnerable communities. The proposed ruling only perpetuates it and perpetuates that environmental racism that is so prevalent in New Mexico, and it should not be passed or even considered. It is a gross misuse of our resources and your public trust. Produced water is toxic and cannot be fully treated, and we know that. It's been studied extensively and has been talked about extensively here as well. Becoming more lenient in any fashion with untreated toxic waste is unacceptable, especially when the health risks are apparent. We cannot and should not be putting New Mexicans' health at risk in any capacity, but especially when our state is still reeling from the ongoing pandemic. It makes absolutely no sense to knowingly put New Mexicans in danger. And we need tighter regulations to protect our communities. The current proposal needs to be suspended because of the aforementioned reasons and because there has not been adequate communication with community members about what the true implications would be. If anything else is to be proposed, then it absolutely needs to be talked through with the communities that are affected and needs to be restricted. But even better than that, it would be we need to stop fracking altogether and to stop the production of toxic waste. That is the only way to properly serve New Mexicans and ensure the safety of our communities, our land, our water, and our ways of life. Thank you.
Thank you, Ms. Johnson. I believe we have 2 more names. Nancy Galloway and Valerie Gramillion. Nancy, are you with us?
Yes, can you hear me?
Yes, we can. Please state your name, any affiliations you may have, and you have 5 minutes.
Hi, my name is Nancy Galloway. I'm a concerned citizen with no formal affiliation with any other group. I live in Albuquerque, and could you please let me know if my voice starts to break up?
Yes, we'll do. You sound good right now.
Great, thank you. Drilling one well in the Permian Basin requires more than 11 million gallons of fresh water. 11 million gallons of fresh water destroyed for each well. And we live in a semi-arid state where water is quite scarce. Does that make sense? It doesn't make sense to me. For every barrel of fracked oil, 4 barrels of toxic wastewater is produced. Where to put this toxic byproduct, called produced water, is a problem for the oil industry. This so-called produced water should be called poisoned water because it's a toxic brew, dangerous for humans and other living things. It contains waste, among many other cancer-causing toxins, and for those reasons alone, it should never be used on our crops or on our roads. It should never be allowed to contaminate our precious groundwater. I suppose it would be nice if all the toxic fracking water could be treated and reused safely, but unfortunately, less than a quarter of the about 1,200 chemicals identified in produced water have an approved analytic technique. In other words, even after being treated, it can't be tested and analyzed to determine its safety. And if someone did eventually develop analytical methods to determine the safety or not of treated produced water, the extreme methods of water treatment that would be required to restore it to a truly safe form would be prohibitively expensive. And all the toxins removed would still need to be dealt with. Far better that we prohibit the toxic practice of fracking altogether allowing us to save our precious and scarce fresh water resources for drinking and agricultural needs. We all need water to live. We don't need oil and gas to live. Quite the contrary, oil and gas is progressively making our planet's climate unlivable. It would make much more sense to transition to clean, renewable energy like solar and wind as quickly as possible and save our fresh water for drinking. Our state has a lot of solar and wind. Government is tasked with protecting citizens' health, our water, and our environment. Please do so. I support Daniel Timmons' opening statement and Mariel Nanasi's 100%, as well as Rebecca Sobel's public comment this morning. It's terrifying, the rules that are being proposed here, and without fully taking science into consideration. New regulations must respect the science. It is incumbent upon the OCD to take a hard look at the existing science that warns against allowing the use of wastewater from oil and gas wells to be used at all outside the oil fields before adopting new rules. Lab experiments have demonstrated that nearly all of the metals from these wastewaters leach from roads after rain events, likely reaching ground, and surface metals from these wastewaters leach from roads after rain events. Pennsylvania and 4 other states have banned road spreading of wastewater from hydraulically captured wells, and New Mexico should do the same. OCD has not established appropriate regulatory procedures and have failed to enforce the ones they do have. Given the current shameful history of widespread contamination by the oil and gas industry, it would be a violation of the New Mexico Constitution and our laws to consider expanding the use of oil and gas wastewater outside the oil and gas fields. That's all. Thank you for allowing me to speak.
Thank you. Our last one is Valerie Gramillion.
Hi there. I'm here, but I would like to request to speak tomorrow because when the email that I received from Florine Henderson said I would not be allowed to speak today because I did not get my request in time. So I would like to speak tomorrow. Can you please tell me around what time that might be or what the actual timing, window would be?
Yes, you can speak tomorrow. We will call everybody's names today who were not responsive today. We will call them again tomorrow. We plan to begin the meeting tomorrow with public comment. So we estimate. Okay. I don't have an exact time for you, but the meeting starts at 9 a.m. tomorrow morning, and we will, start right away with public comment again.
Okay, great. Thank you very much.
Thank you.
I don't know how.
This concludes the first round of public comment. If you're a member of the public and still wish to address this commission, please email Florine Davidson prior to 3 p.m. today, which is in a short amount of time. At the email listed on the hearing notice, and you will be permitted to provide public comment tomorrow morning when this hearing is reconvened at 9 a.m. Just also reminding people, if we called your name today and you were not able to participate, we will call your name again tomorrow. We will now move to the presentation of technical testimony from the identified parties, beginning with the division. The division may now present direct testimony on the proposed rule amendments. Division, will you please call your first witness?
Good afternoon. The Oil Conservation Division has one witness.
I can't hear you, Cheryl.
Miss Beta, you're cutting out.
Yes.
Should I try it without the video?
That's good right there.
It sounds
Okay.
better at the moment.
Okay, can you hear me?
Yes, ma'am.
Okay. We have one witness, William Brancard. Do you need to swear him in?
Yes. Will the court reporter please administer the oath?
Yes, Mr. Brancard, this is Irene, the court reporter. Can you hear me?
Yes.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Please proceed with this witness.
Please state your name for the record.
My name is William or Bill Brancard.
Miss Beta, we can't hear you very well. We can hear Mr. Brancard very well, though.
Okay.
Yeah, I think it's better if you, I don't know, maybe twist it towards yourself. Okay, would you like to continue, Miss Beta?
Yes. Please state your name for the record. And on whose behalf are you testifying?
I am the general counsel at the New Mexico Energy, Minerals, and Natural Resources Department, and I am testifying on behalf of the Oil Conservation Division of the Energy, Minerals, and Natural Resources Department.
Thank you. Miss Beta and Mr. Brancard, I think when you're each speaking, can you twist, I guess, whatever it is you're twisting towards yourself?
The laptop, okay.
Yeah, I think if the laptop is pointed at you, we can hear you well. When you're off to the side, we cannot hear you.
Okay, did you get the last part?
If you just want to repeat, I would repeat it, please.
Okay, thank you. I work for the Energy, Minerals, and Natural Resources Department as general counsel, and I'm testifying on behalf of the Oil Conservation Division.
Did you submit pre-filed written testimony?
Yes, I did.
Do OCD exhibits 3 and 4 contain your pre-filed testimony?
Yes.
Do you adopt your written testimony today?
Yes.
Does the OCD support any of the proposed modifications that were submitted by other parties?
And I can now go through some of those to explain what our position is in regards to these changes that have been proposed by other parties. Can the commission hear me?
Yes, sir.
Okay. First of all, just as background about this rule proceeding, it is, as we've been accused, a narrow rulemaking. Okay, we are seeking basically here to accomplish one task, which is to remove conflicts between our existing regulations and the new statutes passed by the legislature under House Bill 546 in 2019. That is the primary goal of this rulemaking. This rulemaking is not designed to deal with all the potential scientific and technical issues dealing with produced water. That's why you're having a lawyer testifying here, not a scientist or an engineer. But please be clear that this is not the only rulemaking that our agency is working on in regard to produced water. We are working with the New Mexico Environment Department, the Produced Water Research Consortium, to develop better data and science regarding produced water. The Environment Department is working on proposed rules. We need to make our proposed rules consistent with theirs when they deal with the science around produced water. We also have a number of other rules that deal with produced water, and so that should be also made clear here. Rule 34, at which we are referring to here as Rule 19.15.34, is not the only commission rule that deals with produced water. The commission has a number of other rules that actually go into greater detail about certain activities and facilities that deal with produced water. From Rule 19.15.17, which deals with pits and impoundments, Rule 19.15.26, which deals with injection wells, which is the primary disposal option and reuse option for produced water and is governed by the Safe Drinking Water Act and EPA. 19.15.29 and 30, which deal with spills and releases and cleanup of spills and releases. And 19.15.36, which deal with surface waste management facilities. All of these relate to produced water, and as we move forward, coming up with additional changes related to the regulation of produced water, we will likely be addressing a number of those through amendments to those regulations, as well as potentially adopting new regulations. For instance, in the natural gas waste rule or methane rule proposals that the division has put forward in the last couple of weeks, there are rules governing pipelines. Pipelines are a key element of how produced water is also transported. So we'll be looking at those rules as potentially a model for helping to regulate produced water. So finally, we also, as it's been obvious, everyone else has commented, we do need more data. We do need more science. We appreciate all the input from folks about
this meeting
scientific
needs to
stuff.
be canceled. This meeting needs to be canceled. This is an illegitimate meeting. Y'all need to be canceling this meeting right now. I don't understand how you're still doing this. This is not okay. This meeting needs to be shut down.
Thank you. Please continue, Mr. Brancard. And if that type of interruption happens again, you will be
canceled. This needs to be canceled. Needs to be canceled, y'all.
Thank you. You will now be removed from this meeting.
I don't care. Cancel this meeting. This is not a legitimate meeting.
Thank you. Please proceed, Mr. Brancard.
So as others have mentioned, we do need more data. We do need more science. That is a reason why we're introducing the concept of the water use report in this rule to fill a gap that we have in our data on the fact of where produced water goes. We have a sense of how much water gets used in disposal wells, how much water gets used in enhanced recovery operations, but we don't have a good grasp of how much water is used in the recycling in oil and gas production. And as I mentioned, those three items, the disposal through deep injection wells, the reuse of produced water in what's called enhanced oil recovery operations, and the recycling of produced water in the drilling operations. Those are the only three operations, types of produced water uses that we currently allow and regulate. And so to make it clear,
we don't want.
There is nothing in this proposed rule that allows any use of produced water outside of the oil and gas industry. That's the exact opposite of what we're trying to accomplish here. House Bill 546 made it clear that our division, which had limited jurisdiction over certain uses outside of the oil and gas industry, no longer has jurisdiction over those uses. And we are changing our rules to make that clear to everyone. That is what our jurisdiction is. It's now limited only to disposal and uses within the oil and gas industry. And so with that, I'll try to look at a number of the changes. I really appreciate all the changes that have been imposed. We have seen a number of them. Amigos Bravos, Environmental Defense Fund, Audubon Society, Sierra Club, Wild Earth Guardians, New Mexico Environment Department in their written comments had some, and the New Mexico Oil and Gas Association. Starting with the water use report, New Mexico Oil and Gas Association had a small change, which is fine, but Sierra Club and Wild Earth Guardians had much more detailed changes to the water use report. And frankly, almost everyone disagreed with our use of the phrases potable and non-potable water. That's fine. They can disappear. So we'd like to look at and go with the ideas put forward by the Sierra Club in terms of how they rewrote 19.15.16.21. What it does, and what's different from not only getting rid of the potable, non-potable terminology, but it creates another category, a fourth category, which is water other than produced water that is greater than 10,000 or more TDS. That's beyond what all agencies consider fresh water, so that's another distinction. As the Environment Department said, they are in agreement with that distinction. So are we, as long as the Commission is agreeable that that's within the scope of this rulemaking, that addition. Okay, they also require in their proposed change to the water use report that we compile regular monthly reports about this water use reporting and put them up on our website statistics and reporting pages. That's perfectly fine. Our hope, and we provided in our exhibits an example of what that reporting would look like, where our hope is reporting is all done electronically and can immediately be put into a database and be made publicly accessible. We have no problem with having that report. On to Rule 34, 19.15.34. In the scope section, section 2, Wild Earth Guardians proposes an additional sentence that says that this rule, 19.15.34, does not authorize any of these uses of produced water that is not directly related to the exploration, development, production, treatment, or refinement of oil and gas. We think that's what the statute says, and so we don't have a problem with that, particularly if that sentence can really clarify some of the misunderstandings here, that in some ways that we are allowing uses outside of oil and gas through this rulemaking. We don't think we are. I think our language is quite clear about it, but I think this makes it even clearer. And so that's the areas, that's the change to 19.15.34.2 that we would be fine with. In addition, Wild Earth Guardians makes a proposed change to 19.15.34.3, which adds in the phrase that has been amended in the statute in a manner that protects public health, the environment, and fresh water resources. That's fine to have that language in there. It's in the statute. It clarifies our standard, which frankly, it doesn't really change our standard because we have the same standard not only now under B15, but we have it also under B21 and B22 dealing with regulation of wastes. So that's fine to have that phrase in there. It's out of the statute. We're totally okay with that. When it comes to 19.15.34.8, there's a number of changes, wording changes that the New Mexico Oil and Gas Association did that tried to get our rule to comply with the language that's used in another rule, 19.15.26. So in A1, that's what their goal is. We're fine with that. A2, rather than simply repeating exploration, drilling, production, treatment, or refinement of oil and gas, they simply say within the jurisdiction of the division, that change is fine. So finally, the New Mexico Environment Department in 8A6 proposes language that adds to the release section to say this is releases for activities related to the exploration, drilling, production, or treatment of refined oil and gas. Adding those words into it to make it clear that the releases that are covered under the Oil and Gas Act are simply the releases that will be related to oil and gas in our jurisdiction. They're fine. They proposed that, or they offered the language that the Oil and Gas Association proposed earlier within the jurisdiction of the division. That would make it more clear if you have a release when you have to report to our agency and when you have to report to the Environment Department for release. So those are the changes quickly that we are okay with. And I think we're open. Do we have any more questions? Are we open for? We're open for questions from the commission.
Okay, the commission will conduct their questions at the end. Namoga, do you have any questions for Mr. Brancard?
Yes, Madam Chair, this is Michael Felderwart. Can you hear me?
Yes, we can.
Okay. Mr. Brancard, I believe you testified as to the goal, one of the goals of the Produced Water Act in your testimony. Were you involved at all with the passage by the legislature of the Produced Water Act?
Yes, in a minor way. The bill was introduced initially by people within the oil and gas industry. The state agencies who were affected by it, our agency, the New Mexico Environment Department, and the Office of State Engineer, obviously were very interested in what this was doing to the state's regulation of produced water. And so all three agencies became involved in it as the bill moved further to try to refine it and make it more palatable to the state agencies.
Is it fair to say that one of the goals of the legislature in enacting this statute was to encourage the recycling and reuse of produced water by the industry?
You know, you have to read the intent of the legislature from the words that are on the paper. By eliminating certain practices that discourage the use of recycled produced water, and by clarifying ownership and responsibility for produced water, one could infer that they were encouraging the reuse of produced water, certainly within the oil and gas industry.
Okay, and in fact, the legislature also then made sure to define produced water, correct?
Right, they made a minor change to the definition of produced water.
Okay. And as I understand your testimony, one of the goals of your rule here is to obtain data on the reuse of produced water by the industry.
That's correct, and frankly, on what is being used in drilling.
Okay.
Produced water and fresh water.
And as I'm going to let that pass for a minute, I think. And so there's a portion now of your rule then that requires operators to file a report on the types of water that they utilize when they are developing and drilling oil and gas wells.
That's correct.
Madam Chair, may I share?
Please, I'm sorry, Mr. Felderwart,
Sure.
Can you hold a moment? Lynette, would you please mute your microphone and keep it muted?
Okay.
Yeah.
Thank you. And Mr. Brancard, if we're going to obtain data on the amount of produced water reused by the industry for drilling, then it's important to report it as produced water, correct?
Yes.
Okay. And then is that why then the draft rule requires operators to report either as produced water, and then if it's not produced water, there are some categories that you initially created of the types of non-produced water that is to be reported, that being potable or non-potable.
Correct.
Okay. And Madam Chair, is it okay if I share a screen?
If you can, yes.
I'm going to try. Let's see how this works, okay? I'm having the same trouble you did. I'm unable to share. Okay. And as I understand it, you've examined the Sierra Club's proposed modifications.
Yes.
And in terms of the reporting under subpart 16.21, and I apologize, I was hoping to be able to bring it up, but apparently can't. But you were talking about part 16.21, correct?
That's correct.
All right, I am going to try to go to that. Do you have that in front of you, Mr. Brinker?
I do.
Okay, great.
We're trying to change your permissions real quick. And see if we can
Oh, that'd be nice.
If you could
Should I wait?
just a second.
Okay, let me try it now.
It may not be quite there yet.
Can you see?
Go. Yep.
Bingo. Okay, great. This is a section you were talking about, and are these the changes, Mr. Branker, that the division considered to be appropriate in order to accomplish your goal?
Yes, we did not oppose these changes.
Okay. And as I look at it, what they're proposing here is a break, and I'm here at 16.21, the breakdown of that amount by types of water, including, and then the first category would be produced water, right?
It should be.
16.21A.
Oh, yes, I see it.
Okay. The second category would be water other than produced water that has 10,000 or more milligrams per liter TDS.
Yes.
Okay, and it would be important to have other than produced water so that you don't get mixed up in the event that they're reporting produced water.
Correct. I mean, the goal is that these 4 categories or 3 categories add up to 100%.
Okay, all right. Do you think it would be appropriate in order to make this, and then let me finish, the other 2 categories would be water other than produced water that has more than 1,000 milligrams per liter TDS, but less than 10,000. And then the 4th category would be water other than produced water that has less than 1,000 milligrams per liter TDS. Those would be your 4 categories?
That's correct.
Okay. Would it therefore be important then, do you think, to take out, for example, the language including, so that it's clear that operators are to report either as produced water or, if it's not produced water, under one of these other 3 categories?
If that would help the understanding of the section, sure.
Okay. Okay, and then I think I'm going to do a switch on you here, and I'm going to go to what's been marked as, what was NMOGA's Exhibit A, which I believe is OCC Exhibit 3D. And we just went through 16.21, so I'm going to go to the second page. And this is part 34.8, where NMOGA had proposed some language changes. Mr. Brankett, are you there?
Yes.
Okay, and I believe you understand the reason for these changes?
Yes, these are words, these are terms that are used in other regulations, particularly 1915-26, and we don't want to conflict with that regulation.
Okay, and so you agree that these 2 changes shown up here under Exhibit 3D under 34.8, which are highlighted, that those would be appropriate?
Yes, we don't oppose those changes.
Okay, and just for clarity in the record, this particular exhibit shows in unhighlighted red line format the division's initial proposals, correct?
Correct.
And then the highlighted red line that we see on here would be what the language change that NMOGA is proposing.
That's my understanding.
Okay, great. Thank you for your effort here, and that's all the questions I have.
Thank you, Mr. Feldor. Wild Earth Guardians, would you like to cross-examine the witness?
Yes, Madam Chair. And I would also like to share my screen. I'm not sure if I have that permission yet, but maybe we can get that process started.
Go ahead and try, and if it doesn't work, we'll see what we can do.
It doesn't appear to be working. So. It's grayed out as an option on my screen. Okay, it does give me that permission now. I'm not quite ready to share it, but I will there. It looks like I have that option. So thank you. Again, this is Daniel Timmons on behalf of Wild Earth Guardians. Good afternoon, Mr. Brancard. In your oral testimony, you described this rulemaking as part of to implementing the Produced Water Act. Would you agree with that?
I missed a few words there. Sorry.
Okay. I think we're getting some background noise from folks that are not muted. I think that would be very helpful. Okay, so in your oral testimony, you described this rulemaking as part of a phased approach to implementing the Produced Water Act. Do you agree?
Yes.
Would you also agree that there was nothing in the public notice for this rulemaking that described a phased approach?
That's right. I'm sorry. No, we did not do that. No.
Right. So nothing that outlined future OCD rulemakings in that public notice?
That's correct. And these are rulemakings related to produced water. They're not necessarily related to the Produced Water Act. Yes.
Has OCD issued any, aside from this rulemaking, any formal public notices for future rulemakings regarding produced water?
No.
Or provided any public timetable for such rulemakings?
No.
Is there any statutory timeline that would require OCD to promulgate additional produced water rules by any certain date?
No.
Was that a no? I'm sorry.
No, sorry.
So the public effectively has no certainty that OCD will actually promulgate new produced water rules within, say, the next year.
Given all the circumstances going on with pandemic and our involvement with other rulemakings, it's hard to guarantee any schedule.
Is OCD going to wait for future rules to be put in place before it allows the recycling and reuse of produced water under these rules? These being the proposed rules.
Well, the proposed rules limit our authority to approve the reuse of produced water. And so that came into effect with House Bill 546. We didn't need these rules to limit our authority. Our authority was already limited, in our opinion. This just makes it clear to the regulated community and others that we have no authority over any uses outside of the oil and gas activities.
Would you agree that OCD does have authority to issue permits for the use of produced water within the oil and gas industry?
We do, and we issue permits for disposal wells under our authority delegated to us under the Safe Drinking Water Act. We issue permits for injection wells dealing with enhanced oil recovery, also under Safe Drinking Water Act authority. And the rule we're looking at here, Rule 34, deals with the recycling of that water just for the use in drilling activities. So those are the three areas that we cover.
Just drilling activities or other activities within the oil and gas industry, to be clear?
Well, these recycling facilities and containments are designed to deal with drilling, and that's what they're there for.
The rulemaking notice, going back there, indicated that this rulemaking, quote, implements the changes in produced water management and authority enacted by HB 546. Do you agree with that? I can pull it up if you need to.
Yeah, I'll go with what you're saying.
in your written testimony, you noted that produced water reporting would aid in future regulatory decisions. Is that correct?
Yes. Yes.
And that obtaining what you refer to as, quote, basic information regarding the use of produced water in fracking is, again, quote, essential to implement the goals of HB 546 and will inform future policy decisions. Agree?
Yes.
So based on that statement, would you agree that OCD currently lacks basic information needed to implement the goals of HB 546?
In this particular sense, we lack some basic information, and that's where does all that produced water go? We have a sense of where it goes down injection wells or enhanced oil recovery wells, which is probably around 90 to 95% maybe. But we don't know what's being used in drilling, and that's obviously an important issue, as one of the commenters said earlier about trying to discourage fresh water use in drilling.
Okay, thank you. So I'm going to share my screen now, and hope to. Looks like that's going to work. Great.
Make it like slightly larger.
Oh, am I?
Just if you could, like, I don't know, hit the plus sign. I think up top it says 75%, maybe make it 100.
Oh, on the PDF itself.
Yeah, yeah.
Okay.
Yeah, that's much better.
Okay, great. So this was included in OCD's pre-hearing statement as OCD Exhibit 4. I think that number has stayed the same, but you would agree that this was a true and accurate representation of OCD's Exhibit 4 in your PowerPoint of your testimony.
I'll take your word for it. I assume so, yes.
So far, at least. So let's see. There we go. So I want to take you to what is page 2 of your presentation, where you discuss the goals of rulemaking. So this page here, let's see, identifies the goals of this rulemaking. Is that correct?
Yes.
Based on this slide, did OCD identify the protection of public health, the environment, and freshwater resources as a goal of this rulemaking?
We're just trying to avoid conflicts with the statute. That's what it says, and that's what we're doing.
So this is page 3 of the same presentation, identifying what you describe as the key changes in HB 546, including the Produced Water Act. Based on this slide, did you identify the protection of public health, the environment, and freshwater resources as a key change of HB 546?
No, frankly, because it was simply taking language that already existed in the Oil and Gas Act and putting it into this particular subsection, subparagraph, actually, within the Act. That language already existed.
The presentation, again, states that HB 546 encourages the reuse and recycling of produced water in the oil and gas industry, correct?
Yeah, that's the way we read House Bill 546. I'm not sure everybody else reads it that way, but that's the way we read it.
With respect to OCD's authority, HB 546 actually restricted OCD's authority to authorize certain types of produced water reuse, right?
Reuse outside the oil and gas industry, yes, absolutely.
So the Produced Water Act limited OCD's jurisdiction?
Yes.
I'm going to go to page 8 of your presentation. So this is showing the statutory changes in 70-2-12B15 before and after. Again, looking at this statutory change, there were certain activities that were previously within OCD's regulatory jurisdiction that are no longer within that jurisdiction, right?
Correct.
And so OCD's regulatory jurisdiction over produced water is now limited to those activities specifically listed in the statute in paragraph 15. I'll repeat the question. OCD's regulatory jurisdiction over produced water is now limited to those activities that are specifically listed in the statute at paragraph 15, the right side of the presentation.
Correct.
So OCD cannot authorize any use of produced water beyond those uses listed in the statute.
Yes, that's correct.
Also looking at this statutory change, would you agree that the legislature changed the manner or the standard of protection that underlies OCD's regulations of produced water?
In terms of disposition of water, yes, yes.
So the legislature is now indicated that the new OCD rules should regulate produced water, quote, in a manner that protects public health, the environment, and freshwater resources, correct?
For the purposes of this subsection or paragraph, sorry, yes.
And that was a change from the previous language in the Oil and Gas Act.
Right, we got rid of some archaic language.
And that authorized OCD to regulate produced water in a manner that will afford reasonable protection against contamination of fresh water supplies designated by the state engineer.
That was a phrase in the old statute.
Would you agree that the change from reasonable protection to protects represented a heightened standard of care for OCD's rules?
Well, frankly, like some of the other phrases that got rid of here in B15, we're not exactly sure what a reasonable protection was. We always went with the notion of protection because if you looked at B21, which deals with the handling of wastes, and this would be a waste, it says protects public health and the environment. So we went with that standard.
In paragraph 15 here, prior to HB 46, public health protection was not identified as a standard underlying OCD's regulation of produced water. Is that correct?
It was not specifically put out, yes.
And nor was the environment.
Right, those are in B21.
So, given this new legislative directive, why didn't you identify the protection of public health, the environment, and freshwater resources as a key change in HB 546?
Like I said, that standard already existed in our dealing with wastes under Rule 21, under statute B21. So that was always the standard that we dealt with. We're quite glad that the language reasonable protection is gone because we're not sure what that was, and we sure hope nobody would try to use it against us to limit our authority. And so we're quite happy with that being gone. So it's a clarification. It doesn't really change, in any great way our standard because we always had the standard of protecting public health and the environment.
So based on this new language in paragraph 15, did the legislature direct OCD to regulate produced water in a manner that encourages its recycling and reuse?
The word recycling appears for the first time in here, and reuse. So one could imply from that recycling and reuse are among those types of activities that we should be doing.
Did the legislature authorize OCD to regulate produced water in a manner that protects public health, the environment, and freshwater resources?
Yes.
Are you generally aware that produced water often contains toxic chemicals?
I'm not a science, but I know that produced water contains a lot of constituents.
Including BTEX?
I think I would be aware of that, yes.
Including ethylene glycol or antifreeze?
No, it may, I don't disagree with that.
Chemicals known to cause cancer? Carcinogenic chemicals?
I wouldn't be someone who would have the expertise on that, but.
Has OCD offered any technical witnesses at this hearing? That
No,
would be
because this is not a technical rulemaking. This is a legal rulemaking.
Are you aware that there are chemicals known to disrupt the endocrine system in produced water?
There may well be.
High levels of
I'm not personally aware of it, but.
I understand. Are you aware that there are high levels of salts in produced water?
That I'm certainly aware of, yes.
And metals?
Metals, yes, salt and metals.
Volatile organic compounds, or VOCs?
Yes.
Are you aware that VOCs are a primary precursor pollutant to ozone pollution?
Yes.
And are you aware that ozone levels in the Carlsbad area are out of compliance with federal ambient air quality standards based on monitoring data from 2017 through 2019?
That's what the Environment Barn tells us.
Are you aware that produced water may contain radioactive materials?
I've seen papers on that, yes.
And that significant levels of uranium have been found in produced water coming from the Permian Basin specifically?
That I'm not aware of, no.
OCD's proposed rules don't require testing of produced water for radiation levels prior to recycling or reuse, do they?
They do not.
And no radiation testing would be required under these rules before produced water could be transported for reuse or disposal.
Within the oil and gas industry.
Within the oil and gas industry.
That's right. We haven't addressed that issue yet.
And OCD's proposal would not require toxicity testing of produced water for use within the oil and gas industry.
We have not addressed that issue yet. It is a potential issue, and we may address it in future rulemaking, but we have not addressed it yet.
Are you aware of scientific reports indicating that the toxicity of most of the chemicals found in produced water has not been previously studied?
I've seen papers saying that. Well, there hasn't been, no standards have been developed for them. That's what I read. There may have been studied, but no standards.
Okay, so let's turn back to the rule itself. Let's see, what page am I on? I'm going to go to page 14 of your presentation. So turning back to the regulations here, in paragraph 1, OCD is not proposing, or I should say, OCD is proposing to not require a permit for the reuse of produced water for the drilling, completion, producing, or enhanced recovery of oil or gas. Is that right?
We do not require that now, and we are not changing that.
Absent a permit requirement, how does OCD ensure such uses are conducted in a manner that protects public health?
We regulate the facilities that are used in these matters, the impoundments, and hopefully we will regulate more with pipelines, et cetera. And that's where we try to protect the public from any potential impacts of produced water.
So looking at paragraph 4 here, paragraph 4 says that produced water will be handled in a manner that protects public health, the environment, and freshwater resources, correct?
Right, we're replacing the old statutory language with the new statutory.
But these proposed rules don't actually define what that means, do they?
We deal with produced water in a variety of manners that we hope to have that goal of protecting public health and the environment and freshwater resources.
This rulemaking proposal doesn't specify operational requirements for produced water handling, right?
This rule, well, yes, it does. Actually, this rule deals with containments and recycling facilities. Rule 34, that is.
Okay, I was referring to the proposed rule, but I'll move on. Does this rulemaking proposal specify standards for protective equipment that would apply to workers handling produced water?
We do not regulate worker protection. That's OSHA issue.
Do these rules specify any numeric water quality standards that would apply to any particular uses to be authorized by OCD?
We certainly comply with Water Quality Commission standards for groundwater and surface water, but we don't require that water be of a certain quality before it's used in drilling or put down an injection well.
Or hauled to an injection well site.
Or transported.
OCD's rulemaking proposal does not specify particular safety standards for trucks that would be hauling produced water. Is that correct?
It does not, and I don't know that that would be our jurisdiction. It might be more of a Department of Transportation issue.
And this rulemaking proposal does not specify any hazardous waste training requirements for individuals handling or transporting produced water.
It does not. It's not a hazardous waste, first of all.
Are you aware that produced water can exhibit the characteristics of a toxic waste or a hazardous waste under the RCRA standards?
I have not looked at that issue. I mean, I know it's exempt from RCRA.
Right. Would produced water and other oil and gas waste need to be exempt from RCRA in order to be not regulated under RCRA if it did not meet the characteristics of hazardous waste?
I think you answered your own question. If it wasn't exempt from RCRA, it would have to meet the tests under RCRA, whether it was or was not a hazardous waste.
Why would it be exempt from RCRA standards if it was not characteristic of hazardous waste?
I don't know. You have to ask Congress that, or the EPA.
So beyond the general statement in paragraph 4 that produced water shall be handling and stored in a manner that protects public health, etc., how do these rules, this specific rulemaking proposal in front of the board today, in front of the commission, how does that ensure produced water will in fact be reused in a manner that protects public health, the environment, and freshwater resources?
As I mentioned earlier in my statement, we have a series of rules that deal with various aspects of produced water, whether it's being placed in impoundments at the well site, whether it's being placed in recycling containments and facilities under this rule 34, whether it's injection standards, drilling standards. There's a whole series of rules we have that produced water operations have to comply with that are designed to protect public health, environment, and particularly freshwater resources.
So you mentioned OCD's recent proposal or draft methane rules that have been put out for informal public comment. So you're generally aware of those rules, correct?
Generally.
You specifically mentioned that there are new rules regarding pipelines, correct?
Right, gathering lines, yes.
Okay, I'm going to pull up that rules proposal here. This is the proposed rules to Title 19, Chapter 15, Part 28, that have in fact been included in the case file for this hearing 21281. So scrolling down, starting at 1915.8 here, well, I guess before I get there, would you generally agree that the regulatory requirements in this proposed methane rules are a lot more specific than what's being proposed by OCD here today?
Yes, that rulemaking has gone through an extensive process, technical review and input. And that, that's the kind of rulemaking process we need to go through moving forward with produced waste rules and other changes in the future.
So just to go through a few of these separate changes, starting at point 8, the methane rules proposed include a record-keeping requirement, correct?
Correct.
In point 9, standards for pipeline materials, correct?
Correct.
In point 10, design requirements.
Oh, yes, I see it now. Yes.
In point 11, construction standards.
Yes.
Mr.
In point,
could you please let us know how this is relevant to this produced water conversation, please?
Madam Chair, OCD's charge from the legislature was to adopt rules that regulate produced water in a manner that protects public health, the environment, and freshwater resources. The lack of specificity of how these rules actually do that is relevant to these proceedings. I'm simply drawing a comparison to other rulemaking proceedings that OCD is currently undergoing and showing the distinction between what a real regulatory proposal looks like and what is being proposed here today.
I mean, these rules are in an informal comment period at the moment. These will be debated in front of the commission, I'm sure, at length later. And so I'm just not quite sure, again, how this is relevant to the conversation today.
Okay, I can move on. OCD's proposed produced water rules in front of the commission today include a record-keeping requirement.
There are no change. We have not dealt with the specificity of any of those types of rules at this point.
Okay, I'll go back to your presentation. So this is on page 12 of This Is Back to OCD's pre-filed Exhibit 4. This is referring to the scope of the proposed rules. I appreciate your earlier statement that you would add Wild Earth Guardians suggested sentence at the end. But in this description of the proposed rules, scope of the rules, OCD refers here to the, quote, direct surface or subsurface disposition of produced water, and that second line from the top. What does that mean, the direct surface disposition of produced water?
Yeah, that's certainly language that we could live without, but likely a surface disposition is placing it into impoundments where it would be temporarily stored. And that's what's going on here. In 1534 is a rule that most of the rule it deals with recycling containments, surface facilities where produced water is held temporarily before it is recycled.
In your professional legal opinion, do you believe that OCD has the authority under the Produced Water Act to regulate the reuse of produced water for dust control at a well pad?
Boy, I think we'd be extremely reluctant to allow that. Obviously, we don't regulate anything related to a road maintenance or use, and so I think we can probably view that as similar to road maintenance.
Do you believe that OCD
just spraying produced water on the ground is not something we're in the have any interest of approving. And we certainly wouldn't, without consultation with the New Mexico Environment Department.
Do you think this rule proposal here today is clear about whether such activity, again, the reuse of produced water at a well site for dust control, is prohibited or not?
I'd have to say that, before House Bill 546 was passed, there was a huge amount of gray areas between our authority and the Environment Department's authority. And House Bill 546 did a great job of really narrowing that, okay? That doesn't mean there still aren't some gray areas out there. It would be my opinion that any application of produced water to the surface of the ground would be an issue covered by the Environment Department and their authority under Water Quality Control Commission regulation.
But you acknowledge that these rules still leave some gray area regarding that question.
Well, I think there'll always be gray areas. I think there are far fewer now with House Bill 546. Much, much fewer.
Okay. So I now want to dig in just a little bit into the uses that require a permit under paragraph 1. Again, I'm back to page 14 of OCD Exhibit 4. Uses that would not require a permit under paragraph 1 and uses that would require a permit under paragraph 2. Am I correct that produced water could be used for drilling without a permit under paragraph 1?
I'm sorry, what was the question again?
Is it under paragraph 1, a produced water could be used for drilling without a permit?
That's correct.
But under paragraph 2, a paragraph would be required for other uses of produced water in the drilling. That's enough of an answer for me, I think. Can you explain the difference between using produced
Right,
water?
I mean, we have agreed to a change to subparagraph 2, which would eliminate that phrase in the exploration, drilling, production, treatment to say within the jurisdiction of the division. That was a proposal from the Mexico Oil and Gas Association. I think that clarifies it so we're not repeating drilling both 1 and 2.
So, and that change would basically say that there are specific uses that don't require a permit under paragraph 1, and anything else within the jurisdiction of the division would require a permit under paragraph 2. Right?
Yes, but there are other rules that require permits too. So for instance, on number 1, it says you don't need a permit to use produced water in enhanced recovery or in drilling, say, but you still need a permit to drill that well, to drill the injection well, etc. So it's not like it's no permits for those activities. It's just the reuse of produced water in that activity by itself does not require a permit.
But any other reuse of produced water within the jurisdiction of the OCD would require a permit, right?
That's right.
And you believe that red line amendment offered by NMOGA would provide clarity regarding what uses would in fact require a permit?
Well, it's like you said, it makes 1 and 2 exclusive of each other.
can you specify what uses of produced water would require a permit under paragraph 2?
We don't know. There may be pilot projects, although those are dealt with elsewhere in here. But sometimes, it's impressive often the ideas that the industry comes up with. And so we want to make sure that we oversee any ideas they have about using produced water, and don't let anything fall through the cracks. So while I can't, give you an example right now, that part of that is designed to deal with unknowns, to make sure that we cover those unknowns.
So I guess maybe I'm under these rules, again, that paragraph 2. Do you think that OCD could authorize the reuse of produced water for dust control at a fracking site through its permitting process?
Well, it's my opinion that we couldn't, but I can see where you're getting at here.
Do you think it might help provide clarity to operators and the public to say that explicitly in these rules?
Dust suppression?
Or as you said it, the application of water to land and stop is outside the jurisdiction of OCD.
Untreated produced water? I think that's where the Environment Department is going also, which is why we may want to coordinate with them. I believe they are moving toward rules against any use of untreated produced water.
Okay. Do you believe, based on these rules, that OCD could authorize the use of treated produced water for dust control at a wellhead?
It would have it again. I don't think so. I think the Environment Department would have to approve it, and I think either agency approving it would require that we would have strict standards about any reuse of produced water. I mean, even when we had the authority to approve the use of produced water on roads, we didn't approve any in anybody's memory, because when somebody came to us, we would say, well, here's all the restrictions on it. We wouldn't hear from them anymore.
Okay. Yeah, let's talk about those restrictions and that, specifically that permitting process in paragraph 2. Under paragraph 2, to receive an OCD permit to recycle or reuse produced water, there would be no uniform permit requirements under this proposal, correct?
That's right.
And there's no specific best management practices that all permittees would need to follow in order to receive an OCD permit, correct?
Unless we have something on Form C-147, or we have policies about it, I'm not aware of it.
And there would be no universal requirement that the toxicity of produced water be characterized before issuance of a permit.
Well, but we then jump down to number 4. And so we still have the standard of protecting public health, the environment, and fresh resources. So that would apply to any approval under paragraph 2.
An interpretation of paragraph 4 in the permit approval requirement would be, quote, determined by the district office based upon the proposed use, correct?
Correct.
And it's OCD's position that leaving approval requirements up to the discretion of the district office is appropriate.
Frankly, we'd be fine with eliminating the words appropriate division office in there, appropriate district office out of there. Because the reality is nowadays, almost all those decisions are made in Santa Fe anyway. So an approval by the division would be more appropriate.
Okay. Even if that change were made, approval requirements would still be determined at some point in the future based upon the proposed use, correct?
Right, but they would have to protect public health, environment, and fresh water resources.
So it's your position, OCD's position, that this provides sufficient clarity for operators to understand what's required to obtain an OCD permit.
It gives them direction on who they have to talk to. I mean, that's the issue that we get, is that oil and gas operators come up with ideas. And so you can't just go ahead and do it. You've got to work with us and get a permit. And it's hard to, again, it's the unknown of knowing what exactly what that idea would be. We would have to be specific in each situation about the conditions we put on it, or if we would approve it at all.
So you acknowledge that under paragraph 2 of these proposed rules, OCD could potentially permit some potential future reuse of produced water that we haven't even thought of yet.
That's correct.
And it's OCD's contention that leaving approval requirements for some future potential use we have not even thought of yet, leaving that approval requirement for determination on a case-by-case basis, will protect public health, the environment, and freshwater resources.
That has to be the standard. That is the standard.
I think I can unshare my screen at this point. I have a few more questions, but it might take me a minute. Stop here. All right. So just a few more questions here. One more, I guess, category of questions. Would you agree that spills and releases of produced water occur regularly in New Mexico's oil fields?
Yes.
And spills of produced water are something that OCD has to routinely deal with?
Yes.
Are you aware that OCD's online spills database shows 325 reported spills during the first 6 months of this year?
I'm not aware of that number, but I don't just, if you say that's correct.
And 171 major spills of produced water from January to June 2020. You don't disagree?
I don't disagree.
171 spills in 6 months would be a major spill of produced water nearly every day, right?
Close.
Are you familiar with the major WPX spill that occurred around January 21st, 2020 in Otis, New Mexico?
My knowledge is largely based on what I read in the papers.
And so based on what you've read in the papers, a produced water pipe burst in that incident, correct?
I believe that's correct.
And the pressure was so high that the produced water sprayed on a family home that was 200 yards away, correct?
I think that's correct.
And the paper reported that the produced water sprayed on their yard and their animals and their bodies when they went outside to investigate, correct?
That's what the paper reported.
And the family also reported smelling gas at the time, right?
Yes.
That WPX pipeline that burst was in the oil fields, right?
Yes.
So it was under OCD's jurisdiction at the time it exploded.
Yes.
And that pipeline will remain under OCD's jurisdiction under these proposed regulations, correct?
Yes.
Is there anything in these regulations proposed by OCD that's designed to prevent this type of disaster from occurring again?
That's not the intention of this rulemaking. As I said, we'll be looking at more specific facility rules, but in particular pipelines going forward.
And will OCD continue to issue permits for produced water reuse and allow unpermitted or allow reuse without permits in the interim before any new rules are promulgated?
That's right, yes.
Thank you. No further questions.
Thank you, Mr. Timmons. I think we are going to take a 10-minute break. So it's 3:22 now. We will begin again at 3:32. Thank you.
Madam Commissioner, is the lawyer for Sierra Club going next?
Yes.
Okay, thank you.
Yeah, Sierra Club and then New Energy Economy. Thank you. We'll be back in 10. Hello, everyone. We'll get back started. It's 3:34. Mr. Brancard, are you still with us?
In body, yes.
Great. We will now continue with the cross-examination with Sierra Club. Sierra Club, you can proceed.
Good afternoon, Madam Chair, members of the Commission. I'm Douglas Micklejohn. I'm a lawyer with the New Mexico Environmental Law Center. We represent the Sierra Club with our co-counsel, Kara Lynch. Good afternoon, Mr. Brancard. How are you?
Wonderful. Thank you, Mr. Micklejohn.
Given what you've just been through, I expect that's an exaggeration, but I'd like to start by addressing section 19.15.16.21 of the proposed regulations.
Yes.
It seems to me you said that the Sierra Club's proposed changes were acceptable, but then the New Mexico Oil and Gas Association, through Mr. Felder, were proposed inserting the word either in the introductory language. And you said you were agreeable to that. Am I remembering that correctly?
Yes. I mean, if that clarifies is better than including, then that's fine.
But if the word is either, then, well, we've got 4 categories of fluids here. One is produced water, and then there are 3 categories of water. If the word is either, the operator could arguably only report one of those categories, even if more than one was relevant. Isn't that accurate? Whereas if the word is including, then if all 4 categories are used, then all 4 categories have to be reported.
Right. I think what Namoga's concern is that the phrase including, under the Uniform Statute and Regulatory Construction Act is generally interpreted as including but not limited to. And so I think the point is try to draft this in a way that it's these 4, then they should add up to 100%. So whatever words work, I'm fine with it.
Well, what about language that says something like including whichever of the following 4 categories are appropriate? Including all the following 4 categories that are appropriate.
Well, how about if we just drop the last 5 words? And so it became, and breakdown of that amount by, which I think is actually the Oil and Gas Association's original proposal, to eliminate that phrase types of water.
So the introductory language would end with the word by.
Right, by, colon.
And then it would list the 4 categories.
Right.
Well, you're the regulator. If that language was, if it was changed to be that language, would it be your opinion that in a case in which all 4 categories of fluids had been used, all 4 had to be reported?
Yes.
All right. Well, then if you're amenable to that, then why don't we end the introductory language with the word by?
Yes, that would be fine.
Okay. You were asked, I believe, by Mr. Timmons about public processes for rulemaking. was there a public process by which the division obtained public comments on these specific proposed rules?
Are you meaning the formal process or an informal process?
Either one.
Well, we have to go through a formal rulemaking process, which is what we did, and we're required by the State Rules Act to have a 30-day period for public comment. In this case, I think we had the commission, I think, actually approved 51 days for public comment. There was an informal process in advance of this where I notified stakeholder groups that were involved in a prior rulemaking that came before the commission, which is amendments to our compliance rule, 1915-9 or 5, sorry, 1915-5. And there were 3 groups of stakeholders that were involved in that, and they were informed that we were going to move ahead next with this, and I sent out a draft version of this rule to them to get some comments. I didn't get a lot of comments, and so we asked them again, and NMOGA responded, but that was about it. So yes, we did an informal process. It wasn't as robust as, say, has gone on with the methane rule, which is obviously a much more technically detailed rule. So that is the process. That's a long-winded answer to your question.
That's fine. Do you recall which, if any, community or environmental groups were notified of that process?
Yes, I believe it was Sierra Club, and I believe it was a member from your office, Mr. DeSalen, was notified.
All right. The statute, as the Produced Water Act, discusses protection of public health, the environment, and fresh water. Do you know how that language got into that act?
Okay, you're looking at B15, 72-2-12.
I think that's right.
Okay, so that's actually the Oil and Gas Act. Things a little confusing because House Bill 546, elements of it are the Produced Water Act, and elements of it are amendments to other statutes, including the Oil and Gas Act and the Water Quality Act in particular. And so this was an amendment to the Oil and Gas Act that was part of House Bill 546. And as that bill moved through, there were discussions among various groups and the sponsors about changing that particular subsection of the Oil and Gas Act.
Do you know who suggested that change?
You know, I can't remember, but I liked it.
Okay. So do we. Is it your position that the current commission regulations provide that kind of protection within the oil field?
I'm sorry, you broke up a little bit, Mr. John.
Is it your opinion that the current Oil Conservation Commission regulations provide that level of protection within the oil field?
Boy, that's a matter of debate, both internally and externally. I will say that we're always looking for ways to improve how we regulate and provide that protection.
Given the figures that Mr. Timmons gave you about numbers of spills that have occurred, I think he said in the first 6 months of 2020, and I think he had another time period. Is there an argument that, in fact, that kind of protection is being provided?
Well, I think there's an argument that we need to improve our regulations. You know, we did 2 years ago completely rewrite our cleanup regulations in hopes that making it clear to companies that they had to follow specific steps in characterizing, testing, and actually doing the cleanup and meeting standards, that kind of requirements, which didn't exist before, it was very general provisions, would sort of give them the emphasis to have fewer releases. Maybe it's simply how much production is going on today that we have this many releases. But I think we need to be looking at, as I mentioned earlier, looking at the particular facilities where a lot of these releases are occurring. And that would be pipelines, gathering lines, it would be tank batteries and other facilities that we may need to have really specific standards on that would hopefully prevent more of these releases.
Are there regulations in place now that prohibit those releases?
We actually do not prohibit a release. We require you to immediately report the release and take action and clean it up.
Is it your view that produced water, either recycled or non-recycled produced water, can be used in road construction within the oil field?
That's not something we would approve. It would be up to the environment to determine if that was at all possible.
Would you expect that the Environment Department would require a groundwater discharge permit before allowing produced water to be sprayed on a road or other land surface?
I think we had a recent discussion with them over somebody who had that idea, and I think that was what conclusion they came to.
Is there anything in either the Water Quality Act or House Bill 546 that requires that the Water Quality Control Commission regulations allowing for the use of produced water outside the oil field?
You can read the language that's in the Water Quality Act. I believe they are required to adopt regulations related to that. And whether those regulations would actually allow for those uses, that would depend on how those regulations are written.
But is there anything in the Water Quality Act that would require that those regulations be written in such a way as to allow that kind of use?
It would be my opinion that it doesn't require that.
Okay.
But I'm not the Environment Department's lawyer.
I'm aware of that.
The Control Commission's lawyer.
You're familiar with the Frac Focus website?
Somewhat, yes.
Is it your understanding that trade secret information does not need to be reported on that website?
Right, certain trade secret information. I mean, you have to list all your constituents, but some of them you can, do by more general category, and then say the more detailed information is protected by a trade secret. That's my understanding.
So if a member of a community where hydraulic fracturing has gone on wants to find out exactly what was used in that hydraulic fracturing, that community member may or may not be able to get that information from Frac Focus. Isn't that right?
That's correct. They can get in maybe most, but not all, in many situations.
And isn't it also the case that the Commission's regulations, specifically Section 19.15.16.19, requires that disclosure of constituents used in hydraulic fracturing be reported 45 days after completion of the hydraulic fracturing?
That's right. That's when generally the completion reports are done for a well.
Is it your opinion that that's an appropriate time for reporting from the point of view of a community member who's relies on a well where in an area where hydraulic fracturing has occurred?
The issue there is that the company may not know until they do the fracturing job what actually is going to be in the fracturing fluid. So that was my understanding about why that time frame was agreed to.
Do you know whether the division or the commission has any plans to reconsider that requirement and that timing?
I'm not aware, but we have a long list of potential rulemakings out there, and that could be one of them.
Is that list publicly available anywhere?
No, it's kind of a conversation piece.
Okay.
And frankly, you know, anyone can propose a rule change to the commission.
Right. And anyone includes the division, right?
Right. But it includes public groups, industry groups, whomever.
There are a couple of specific forms that are mentioned in these proposed regulations, Forms C-103 and C-105. What is it that has to be disclosed on those forms?
I believe C-105 is the completion report. So that's all the details about how you drilled your well and how it was actually done. And so that seemed appropriate. And that is also that 45-day time period there. So that's when you would disclose that information with all the other information about how the well was actually drilled. And C-103 is a very sort of generic form that if something doesn't fit into another form, you use a C-103.
All right, I'd like to go back to the Sierra Club's proposed changes. Do you have those?
Somewhere. Uh-huh. Okay, I do.
Okay. In section 19.15.34.3, the Sierra Club proposed adding at the end of that section the language "and the Produced Water Act" with a citation which the regulation should be in a manner that protects the public health, the environment, and freshwater resources. Why does the division object to the inclusion of that language?
We actually don't, but we favor the version from Wild Earth Guardians, which we think is more accurate. That section 70-2-12 is not part of the Produced Water Act. That's part of the Oil and Gas Act. And in fact, that subsection is referenced at the top of that paragraph. So Wild Earth Guardians includes that phrase "in a manner that protects the public health, environment, fresh water resources" up toward the beginning of that section where that where the proper statutory reference is. So that's why we went with them instead of you guys, okay?
That's fine. In the next section, the Sierra Club proposed spelling out 3 objectives of the regulations to provide protection of public health, the environment, and freshwater resources, to prohibit the use of freshwater and hydraulic fracturing unless there's no alternative, and to encourage the recycling or reuse of produced water and activities related to basically the oil and gas industry. Are you amenable to including those 3 objectives in that section?
Well, we kind of liked our version better. We thought it was sort of simpler. I mean, we usually don't, the objective sections are required in each part of the New Mexico Administrative Code. And I think often the goal is to keep them pretty simple and let the rules of the regulation speak for themselves.
All right. You in section 19.15.34.8, your club suggested that a change that would require registration by operators with the division for reuse of produced water. Wouldn't that help in the division's effort to obtain more information about what's happening with produced water?
Well, two things here. One, we see this as a pretty significant change, not contemplated by the proposal that we submitted, to go from a situation which says no permit or registration and now says registration, or in the case of Wild Earth Guardians, permit. So we see that as a significant change, deviation that is potentially outside the scope of this rulemaking, and people would not unnotice that this change could occur. Second of all, the reason the no permit is in there was a policy choice a number of years ago. The idea was to create fewer steps for somebody who is recycling produced water, to encourage the recycling of produced water within the oil and gas industry. And registration, these operators are already going to have to get permits for these activities that are in here. They have to get an application for drilling or a permit for an injection or enhanced recovery well. So they're already going through a permitting process. This would simply add a whole nother regulatory hurdle just because they're happening to recycle produced water. They wouldn't have to have that hurdle if they were using fresh water. So that seems sort of counterintuitive to us.
Well, we would be amenable to requiring registration for both, but the point is that registration is not like getting a permit. If you want to register, all you have to do is send the division a notice, presumably on a division form, saying we're doing this. You don't have to go through any sort of permitting process. And it really seems like that would help you in your efforts to get more data about what's being done with produced water.
Well, I don't see a question there, but I'll answer anyway.
I'd appreciate that.
That's the purpose of the water use report in 1915, 16, 21, to get that information. And you're going to get more accurate information after the drilling is done, because then you'll know exactly what they did, rather than what they thought they might do.
All right. Later in that section, the Sierra Club proposed language indicating that produced water, drilling fluids, and other liquid oil field waste may be used in certain ways in accordance with procedures promulgated by the division. Is the division amenable to putting together procedures that need to be followed in those activities?
Well, frankly, we sort of view this as a restatement of the whole subsection before that, which sort of sets out what you have to do if you're going to reuse and dispose of produced water. And produced water is very broadly defined, so we view that drilling fluids and other liquid oil field waste are sort of covered in there. But we just didn't think that this was necessary, and it might be confusing compared to what we had just stated in the rules.
Is your view about the Sierra Club's proposed subsection C the same?
I think we agreed to the language that Wild Earth Guardians put in the scope, which I think covers this. So,
okay,
one or the other, basically.
And what about subsection E?
Well, that's a huge one. And we view that, I mean, it's certainly something that we have talked about internally and have debated about whether to do that, whether we have authority to do that. And we see that as a major change in the scope of this rulemaking. So therefore, while ultimately that may end up being a good idea, it's not a good idea in this rulemaking.
If the Sierra Club or some other group petitioned the Oil Conservation Commission for rulemaking to make that change, what would the division's position be?
I'm not the division director, and I'm terrible at predicting the future. We would certainly consider it.
As the division's counsel, would you have any advice one way or the other to the division's director?
Well, one advice is we need to be very clear that there is authority under the Oil and Gas Act to have this kind of. I think that's an issue we have not thoroughly researched yet. So that would be my advice, is that we'd have to first sort of look and come up with a good legal opinion about the authority to do this.
Do you have that research ongoing now?
No, because you haven't proposed it yet.
We were waiting for you to do the research and invite us to propose it. You've mentioned several times future rulemakings. Do you have a sense of the timing of those things?
Well, I explained this to Mr. Timmons. There are a lot of unknowns right now with the public health emergency, with resources, with our budget being cut, that make predicting the future very difficult. Right now, the big effort of the agency is to move forward with the natural gas waste rule, aka methane, venting, flaring, and that will absorb a lot of energy in the near future. But as I said, we're looking at a series of other rules changes that we hope to move forward on. And that was part of why I pushed this rule change, is just to get something done.
Well, we commend you for that, but this is perhaps an unfair question, but Michelle Hunter of the Environment Department indicated that the Environment Department was going to be looking at a rulemaking in the future. Do you know what the Environment Department timing is on that?
You know, I don't know the specifics, but I would say that Secretary Kinney in the past has indicated that they may approach produced water in a two-step process. One sort of an interim kind of rulemaking to make it clear that they're not going to approve anything in the short term, and before they get to the more substantive rulemaking about reuse standards and what those might be. So I'm probably speaking out of turn for my brethren over the Environment Department, but you know, that's just to clarify what Michelle said. I think that may be what they're looking at.
Do you know whether the second stage of that is going to be delayed until the consortium that is looking at produced water has completed its work?
I don't know. I think that work will be ongoing for some period of time, so I hope not in some ways. But Secretary Kinney has made it clear from the beginning that, you know, these rules are going to be based on sound science. So until he's comfortable with the science and the information, I think that's when they'll go forward.
Do you know whether either, well, is the division or, as far as you know, the Environment Department doing any research on that issue aside from the research that's being done by the consortium?
I'm not aware, but I wouldn't be the best person to ask that question.
Right. I don't have any other questions. Thank you, Mr. Brankard.
Thank you.
Thank you, Mr. Meiklejohn. We will now move to the new energy economy and Ms. Nanasi. Would you like to cross Mr. Brankard?
Yes, please. Thank you very much, Madam Commissioner. Good afternoon, Mr. Brankard.
Good afternoon.
I want to start with sort of where Mr. Meiklejohn left off. I'm particularly concerned with the addition to 19.15.34.87. So I'm just going to read it for the record because so people who are listening can hear it. So your proposal is any discharge, handling, transport, storage, recycling, or treatment for the disposition of treated produced water, including disposition in road construction maintenance, roadway, ice or dust control or other construction, or in the application of treated produced water to land, for activities unrelated to the exploration, drilling, production, treatment, or refinement of oil or gas, is subject to rules adopted by the Water Quality Control Commission. And you are amenable to adding the words pursuant to the Water Quality Control, to the Water Quality Act. Is that correct?
Absolutely. That's where that language comes from.
Okay. And as you sit there today, those rules have not been written by the Water Quality Control Commission, right?
No, nor is there even an application for a rulemaking.
Okay. So let me just ask you, why would you even, I know that you want to get something done and that's good, but why would you promulgate this rule change without having the rules for the Water Quality Control Commission before you? Like, why wouldn't you be in touch with your sister agency before you went forward?
Well, good question, but we wanted to make it clear in our rules that we don't have authority over any of these activities. Okay, and so this language is sort of a signpost, you might say. In other words, we are deleting the authority that we once had over road maintenance, energy, industrial activities being a source of reuse of produced water that we once had the authority over. And so it sort of leaves open the question, well, who does have authority? Okay, we'll tell you who has authority. This is the language from the Water Quality Act. So it's sort of letting people know, don't talk to us, talk to them. I guess we could have said that, don't talk to us, don't talk to them. But you know, I just thought I thought I was safer just copying the language from the Water Quality Act.
Okay, so basically what you're telling the public is no one right now, no regulatory body, no regulatory agency has any rules about the use of produced water, quote unquote, outside of the oil and gas fields. That's like the purpose here.
Well, no, because there are two things in House Bill 546, okay? There's this language, which is an amendment to the Water Quality Act, okay? And then if you look at 34.8B3, that is language from House Bill 546, which is in the Produced Water Act, which says, for those things that are regulated by the WQCC, you need a permit from the Environment Department. Okay? It doesn't necessarily say that those things with which WQCC has enacted rules. It says regulated by. So we wanted to cover both possibilities here, that A, the WQCC is regulating this, but B, the Environment Department is handing out permits. They are handing out. The Environment Department could hand out permits Or maybe they're the ones you ask for a permit and they just say no. But we're just taking the parts that are in House Bill 546 that move the authority away from us, and we're putting it in front of somebody who might read our regulations, because it's more likely that somebody who has produced water is going to read our rules first, and telling them, go across the street.
Where there are no rules.
Where there are no rules other than the general rules that exist under the Water Quality Act and the ability to issue discharge permits for uses.
Okay. I wanted to ask you, how many vacancies are there right now in the Oil Conservation Division?
I don't know the number. The chair would know the number by heart. But my understanding is that we're down, and we're cheering loudly that we're down to only a 25% vacancy rate right now, down from 50%.
And how many vacancies are there in the Water Quality Control Commission?
Well, the commission's 14 members. I have no idea what the appointment process is.
And regarding NMED, specific to oil and gas, not just everything, what's the vacancy rate there?
I have no idea. I mean, that would be the Groundwater Bureau, most likely.
So I want to go to, so right now, what you're saying in this rule is essentially produced water cannot be used outside industry at all until the Water Quality Control Commission adopts rules. Is that right? Or can it be?
No, I don't. That's an issue you have to address to the Environment Department. I'm saying that our agency has no authority to allow the reuse, recycling, or any use of produced water outside of oil and gas activities.
Why would this be the first rule that you're working to promulgate?
Okay, because unlike the Environment Department, with the Water Quality Control Commission, which currently has no rules that deal with produced water, we do have rules dealing with produced water. And after House Bill 546 was enacted, we went through all of our rules to see whether there was language in our rules that was now in conflict with the new statutes. And that's why, and we found, this is the rules we found, like I said earlier, that we have a lot of other rules that deal with produced water, but primarily Rule 34 is the one where we found language that was in conflict with the new language in the statutes, and we thought it was a good idea early on to just correct those conflicts and get the new language from the statute in our regulations and not have our statutes and rules conflict.
When you were asking Mr. Michaeljohn's question, you say you don't prohibit releases or of spills and discharges. You just require that they're cleaned up. Why don't you prohibit the releases and spills from happening?
We don't have a specific statute or a rule that generically prohibits it. There obviously may be causes of a spillage that involve violations of our rules in terms of how you're operating a well or other facilities that would be a violation. Likely it's somebody acting incorrectly that may have caused this, that would lead us to investigate and possibly see a violation. But there's no specific rule that says thou shalt not release.
Why not?
Good question. I don't know.
Why wouldn't you spend the time? Why wouldn't the Oil Conservation Division spend the time making that rule as opposed to this rule, which that rule would prevent discharges of toxic waste, including hydrocarbons, radioactivity, all sorts of other bad stuff, carcinogens? Why wouldn't you do that first? If your goal is to protect the health and welfare of New Mexicans, and the environment, why wouldn't you focus on the most violent aspect of the oil and gas industry that you do regulate?
Because we deal with the spills when they happen. That has simply been the way it has worked. That is certainly an idea that we can look at. I don't know that it necessarily will prevent releases from happening.
Well, let me follow up on that. We don't know what is going to prevent the releases, but there's clear evidence that this is a major problem. That will go with the number that has been cited most often. We'll go with.
Yeah.
Sorry, go ahead.
No, sorry, I missed your question.
Well, let me just ask you about the number that has been most often cited today is 171 major spills. Of those 171 major spills, what action at all has the OCD taken against any of those major those operators who've caused those major spills?
They're required to characterize it, test it, clean it up.
Well, what action has OCD done in response to any of those 171 major spills?
Made them clean it up.
And has there been any civil penalties?
If they don't follow the requirements under our release rule, yes, there will be. We just enacted civil penalties. House Bill 546 gave us the specific authority to have civil penalties for the first time. And so we are now in the process of issuing penalties against operators. And so we've issued several already, and we will be issuing more, a lot more.
I read about 2 in the paper, but other than, well, can you even talk about those 2? Do you know about that?
I don't know the details on them. Those are just the 2 most recent ones.
Okay, so since 546 was adopted, have there been any OCD fines that have been enacted?
Yes.
And how many?
I don't have that number, but
yes.
I mean, first of all, this House Bill 546 required us to adopt a series of rules in implementing the notice of violation and penalty process, which this commission adopted earlier this year. And so since then, we have been moving forward on penalties where appropriate.
And are you talking about less than 5, more than a dozen, more than 100?
I don't know. It's not more than 100. It's in the tens, I think.
And has OCD moved to revoke the permits of any oil and gas operators as a result of repeated violations and number of discharge incidents?
Mr. Brinkert has, I think answered your question. You've asked it numerous different ways. And you have asked the question multiple different ways. He's answered it multiple times. Can we please move on?
Well,
this is Cheryl Bate. I'd like to object to those questions outside the scope of Mr. Brinkart's testimony.
Well, I want to respond to that and ask Ms. Sandoval if you would rule on Ms. Beta's objection. I'm concerned that there is a very serious, not only regulation problem, but enforcement problem in the Oil Conservation Division. And before the OCD promulgates rules that essentially say, hey, this is somebody else's responsibility when there's no rules established for that, we are concerned that there's basically no one home doing the regulation and the enforcement. And I think this goes exactly, it goes to the heart of what you're trying to do here. I applaud that you want to move forward, but frankly, we have little confidence in the public has little confidence in OCD's ability to promulgate meaningful regulations and then enforce them. So if you don't think that that's relevant in this proceeding, I'd like you a ruling on that.
So Ms. Beta's order is sustained. That was out. Objection is sustained. If I could speak. Her objection is sustained. That is outside of the scope of this. There were no, outside of the scope of this testimony, outside of the scope of this. So please continue with your question.
Thank you. Mr. Timmons had referred to the January 21st produced water explosion that happened to Marlene O'Quan and Carl George, where almost all of the animals are dead. And those individuals have lesions on their bodies as a result of what happened. What has the OCD done relative to WPX and making sure that an incident like that would not happen to anybody else?
Again, I'm going to object. That's outside of the scope of Mr. Braincart's testimony. He testified to Mr. Timmons that he was only aware of the incident because what was in the newspapers.
The objection is sustained. Outside of the scope of this, please stay on topic, Ms. Manassi.
Well, let me ask you this. Has the OCD promulgated any rules for toluene?
Those standard, you're looking for a standard, chemical standards. We generally rely on the standards enacted by the Water Quality Control Commission.
And they have not been established, is that right? For toluene?
I'm not aware whether toluene has standards or not.
And what about ethyl benzene?
Again, we rely on the Water Quality Control Commission. They are the experts in terms of a lot of these standards, and so we rely on their ability to set standards, and we apply them.
And how about xylenes?
Again, I'm going to object. Mr. Brankart's already answered that we rely on the Water Quality Control Commission standards.
Well,
the objection is sustained. Ms. Nanasi, you have basically asked and answered that question multiple times, and Mr. Brankart has already answered to the best of his abilities.
I have asked and answered that question?
Correct. Ms. Beta's objection was sustained. Please move on.
So these are, you would agree that toluene and ethyl benzene, those are commonly found in produced water. Is that right?
I don't know. I'm not a scientist.
Did you read the documents that were submitted to WPX, from WPX to the Oil Conservation Division in that case?
No.
Ms. Nanasi, Mr. Brankart has already testified both to Mr. Timmons and to you that he is just basically aware of that case, does not know the details.
I'm sorry, I didn't hear what you said.
That he is just basically aware that that happened and does not know the intimate details. He's a addressed that to Mr. Timmons, and he has said it to you as well.
Where, do you know where this language from 19.15.34.8 7, where does that come from?
Sure, that comes from the Water Quality Act. It's 74-6. I believe -4P.
And it was also in HB 546, right?
That's correct.
And that language was written by Marathon Oil, correct?
No, it was at that point in the process, a lot of that language was written by a group working with Marathon Oil.
And
Marathon's Oil original draft got changed considerably.
And this pretty much mimics the law in Pennsylvania, correct?
I have no idea.
Do you not know that in Pennsylvania, they have banned the use of produced water outside of oil and gas when they had language almost verbatim as this?
I'm not aware of Pennsylvania statutes, but somebody may have been in order to get that language in the water quality.
Do you agree with NMOGA that these rules are not substantive changes?
These are technical changes designed to comply with the statute.
And
I don't know if substantive is a good word.
Okay, and you, I believe, mentioned that in fact these rule changes are not based on science or health studies. Is that correct?
These rule changes are not designed to deal with technical standards or scientific standards.
As a matter of fact, did anybody review scientific data before promulgating these rules or initiating the rulemaking change?
Certain portions of this rule, particularly 1915, 16, 21, were reviewed by technical staff.
And what scientific data was reviewed before creating 19.15.16.21?
Technical staff is looking at sort of the dividing line, the 1,000 milligrams per liter for total dissolved solids, and whether that was a good dividing point. And so they had their documents that they look at and that they have worked with.
And are you aware of any of those documents that you can state for the record?
I'm not, no.
Other than the water use report section of this rule, to what extent was any other scientific data relied upon?
So Ms. Nanasi, again, I think you've asked this question in 3 or 4 different ways. Mr. Brankart has answered the question multiple times. Please move on.
I didn't ask that question.
You asked about scientific data, what was looked at, what was used multiple times in multiple different ways. Please move on to your next line of questioning.
Can you give us any information other than the water use report and scientific data for the water use report that was consulted in any way when promulgated and initiated rulemaking?
We consulted House Bill 546 and the changes to the Oil and Gas Act and other statutory changes to make the provisions in our regulations consistent, or at least move inconsistencies with the new statutory changes. That was the basis on which this rule change came about.
And you agree, though, that you have to make these rule changes pursuant to the protection of human health, the environment, and water resources, right?
No, those are the standards for which the statute provision is implemented. The rule changes can be typos. I mean, you can make rule changes for anything. It doesn't have to be science.
But it's supposed to be consistent with protecting public health, the environment, and freshwater resources, right?
We put that standard in there, yes.
And given the fact that you're a lawyer, you understand that rulemaking must be based on substantial evidence. Is that right?
That's right.
And what substantial evidence was relied on by the OCD to make these rule amendments?
As I said, House Bill 546. We're making the oil and gas regulations consistent with the Oil and Gas Act, and also the Water Quality Act and the Produced Water Act, all of which were amended by House Bill 546. Just as we did a few months ago when we made the compliance rule for the commission consistent with the changes that are in House Bill 546.
Is there anything else that you relied on other than what you've just testified to?
There are a few little wording changes in the rule that are designed to make it consistent with other rule changes that have happened in the last couple of years. For instance, we don't call them saltwater disposal wells anymore. They're produced water disposal wells. So that change was made in a couple places.
If I can have one moment. How would you characterize the current number of, how would you characterize the decrease in well inspections under Governor Lujan Grisham's administration?
Again, I'm going to object. That's outside of the scope of his testimony and outside of the scope of the rulemaking.
Objection sustained. That's not within the scope of this rulemaking. To stay within the topic of this rulemaking, Ms. Manassi.
Is the purpose of, let me ask you this. You talked about the availability right now. Can you just describe what happens right now with produced water? What happens with it?
You mean, where does it go?
Yep.
Okay. Well, I looked into this a bit when I had to give the talks to during the stakeholder, well, they weren't the public meetings that were organized by the Environment Department, but which our department and the Office of State Engineer participated in, and worked with our staff a bit to try to come up with the numbers. Our best estimate at this point is that about, and of course, this is a number based on maybe a year ago. I don't know what it is today with the downturn in the industry. Is about 60% of the produced water goes to deep disposal injection wells. About 30% or maybe a little more goes to reuse in what are called enhanced oil recovery wells. And then the remainder, which may be 10%, we're looking at as being used to be recycled in the drilling process.
And is there a problem with basically filling up those disposal injection wells and not having enough room for all the produced water that is produced?
Ms. Nanasi, that's really out of the scope of this rulemaking.
Well, isn't it the reason why this rulemaking is really happening is that the industry has so much produced water and they don't have anywhere to put it, and so they're moving to try to create a new market outside of the oil and gas fields. Isn't that what's really happening here?
No, that's not what this rulemaking is based on.
Well, I think that's what's
That's
happening
not what's
here,
in Mr.
because
Breitbart's testimony.
I'm sorry?
But the intent of the rulemaking, if there is any intent other than complying with the words of the statute, which is the primary intent, with the water use report, is to try to see how much produced water is being used in drilling operations. And we have had as a policy for a number of years here, dating back to the last administration, of encouraging operators to use produced water in drilling operations so they wouldn't be using fresh water. Okay? And so if there is an intent here with the water use report, that is what we're following up on. As for their ability to, I can tell you they have applied for a lot of new injection wells across the southeast part of the state. So they are still looking to inject a lot of water.
And because fresh water is scarce, correct?
Well, because we don't think that's really a great use of fresh water. We prefer that it be used for ranching, agriculture, municipal.
And actually, I mean, according to newspapers, I'm sure you read this, like the city of Jal is worried about running out of fresh water for just that, for drinking and for agriculture, right?
I'll have to agree with that because I was quoted in the article.
And so to the extent, so can you tell us about how much, or explain how many applications for new injection wells there are?
At one point last year, we were getting over 100 in a 3-month period. It was a lot compared to previous years. Now, whether they really need all those wells, good question.
And were those permitted?
A lot of them are still in the permitting process.
And so would it be safe to say that the reason that they're asking for new injection wells is because the ones that they currently have are filled up?
I don't know if they're filled up, but there certainly is obviously more demand. There's also a certain amount of competition among companies trying to get, more wells than the other and market their services. So sometimes it's hard to tell whether the demand is real or not.
So this is a really interesting conversation that we're having about. It has nothing to do with the subject of the rulemaking. And again, Ms. Nanasi, I need you to please stay on point and talk about this rulemaking. And if you can't, we will consider cutting your time short. So
can I just ask you something? With all due respect, when the other male attorneys were asking questions about the January 21st incident or other parts of these things that I am touching on, and just following up on a lot of the questions that were asked before, you didn't object to any of them.
So I have allowed you to ask quite a few of those questions already.
Excuse me, Madam Chair, this is the court reporter, and I apologize for interruption, but could I ask you to speak a little louder, closer to your microphone?
Yeah, I'll yell
Thank
a
you.
little louder.
Thank
Ms. Nanasi, I have allowed a line of questions from you, but it has become very repetitive, which was happening with previous cross-examinations of Mr. Brancard. So again, please stay on point here. And let's move along. On the point of the proposed regulation.
Would you say that the prudent path forward is to wait until there are actually rules adopted by the Water Quality Control Commission before promulgating this rule? Wouldn't that be the most transparent way to proceed that was consistent with the public interest?
It's always a debate of strategy about how to do these things. I know we were working with the Environment Department, but we became concerned that, time had passed since House Bill 546 had signed, and we still had these rules sitting there that were in conflict with the statute. So we decided, maybe it was me, to move forward with this rulemaking, on the absurd notion that I thought this would be non-controversial.
Why do you think it's so controversial?
Well, I think produced water has become a big issue these days. If we had a conversation 2 years ago about produced water, it would be the agency and the industry talking because it wasn't a public issue. But it's become a public issue, and that's fine. I mean, I think it's an important issue for the public to be aware of.
Well, hasn't some of the controversy come to the fore because there are these other states who have banned the use of it outside of the oil and gas fields and are concerned that that as one of them, and then the other is that the produced water that's in the oil and gas fields are being discharged on a daily basis without any meaningful regulation. That's what the concern is, aren't those the concerns?
We're not allowing any discharges of oil and gas produced water anywhere like that. So if that's happening in other states, I hope they get control of it.
Well, I asked you that before and you said you don't prohibit that release. And as a matter of fact, I know that WPX, the very next incident after the January 21st incident that's on your website, was WPX admitting that they illegally dumped produced water and nothing happened to them. And those are the concerns. And you're the regulatory body. And so here we are talking about outside, inside. It's
Ms. Nanasi, I need you to ask a question. This is not a monologue. Please ask a question.
That's my question.
You're going to have to restate it because I did not hear a question in there for Mr. Brainhart to answer.
So isn't it a concern that it's being produced water is being discharged already without repercussion inside the oil and gas fields, including the WPX illegal dumping where they admitted it to OCD and nothing happened to WPX when they just discharged. I think it was 13 barrels if my memory serves me, but it might not be perfect in that regard, but I'll look it up.
we're always concerned about activities in the oil and gas area. I mean, that's why we have inspectors. That's why we're out there looking for these things. We can't simply rely on the industry to tell us exactly what they're doing all the time. So we have to be out there checking it out. But we don't allow these activities. As you mentioned, WPX said it was an illegal discharge.
But nothing happened. How come?
I don't know. I don't know the situation that you're talking about.
Okay, well, I'm going to tell you what.
Mr. Brancard has said over and over that he only has a peripheral understanding of WPX's incident. Please move on. I do not want to have to repeat that. That will be a third time I would have to repeat it if I have to say that again, specifically on the WPX issue.
Well, I'd like to bring to your attention, Mr. Brancard, I'll tell you the incident number, NRM 200-695-6859. And yes, we are, New England County is making a specific request for you to investigate that. And
Ms. Massey, can you please ask a question of Mr. Brancard?
You just said that you're concerned with inspections. I want to ask you about this. The legislature, in its first quarter fiscal year 2020 report, said that OCD attributes fewer inspections and a lack of compliance with permits and regulations to compliance officer vacancies. Currently, half of OCD's compliance officer positions are vacant. I'm asking you, sir, what is OCD doing about that?
Well, that's, at the end of the last administration, we were pretty much wiped out. And, under the leadership now, we were greatly reducing those inspector position vacancies. It's a challenge. Hiring people in parts of the state where they can get paid a lot more by the industry is a huge challenge. And so we're having to be creative, having to reorganize, come up with all sorts of ideas to try to make this work. But it is a challenge to hire people for these positions. We would love to have 100% filled positions in the agency. But it's a lot of work at this point. We're having to move people to different offices just so we can recruit better. So it's an enormous bureaucratic challenge to overcome these vacancy rates.
So in terms of public confidence in the OCD's ability to regulate this industry, I hear you, and I wish that you had more money, and I wish that there was better regulation and enforcement. So we share that. What I'm concerned about is that's not stopping the permitting for new wells to be drilled from operators. How do you justify that? If you can't regulate them, why are you permitting?
And I'm going to object. That's beyond the scope of his testimony and this rule.
Objection is sustained. Please stay on topic, Ms. Namaste.
Have you agreed to the Sierra Club's 19.15.34.87C? Suggested change?
Let me find it here. Well, my response to Mr. Micklejohn was that a similar statement was offered by Wild Earth Guardians for the scope of this rule, and we agreed to that. So that's, I guess, why we didn't agree to this specifically. But the commission can look at it and whether that's a better place to put that language or not.
isn't the proposal by Sierra Club, specifically 19.15.34.87C, more aligned and just clearer with your testimony that you don't want to allow produced water to be, discharged? I mean, doesn't it put oil and gas operators on notice very specifically? And wouldn't that give you an extra rule to use if they violate that by illegally dumping, for instance?
Again, it's just, as I said, we agreed to language from Wild Earth Guardians in 34.2 that basically says the same thing. And if the commission thinks the language that you're referring to is a better way of doing it, that's fine. I think they're, making it explicit, as you said, is not a bad idea.
And that would reinforce your commitment to discourage discharging of produced water. Isn't that right?
Right. I mean, the difference between the two proposals is that Wild Earth Guardians basically says this rule doesn't allow it. Okay. What Sierra Club says is sort of broader, which is, yes, we don't allow it. So either way.
I mean, I don't want to make the chairwoman irate with me, but wouldn't I mean, it's a problem. It's a serious problem, the number of major and quote minor spills. And if you had something as explicit as this, then you could point to it and say, hey, when
Nancy, please testify on behalf of Mr. Reichard. Please pose everything as a question. Everything needs to be posed as a question, not as a statement.
Wouldn't this be a tool that you could point to when produced water was discharged on in or outside the oil and gas fields, if it was as explicit as
Well, maybe, but the issue is if it's discharged outside of oil and gas activities, that's not ours to enforce. That's the Environment Department's job to enforce under the Water Quality Act. So we would certainly work with them. We also have authority under the Water Quality Act to a certain extent, but the Produced Water Act was pretty specific that they're the ones, you can't do it. You can't do that without a permit from them. And so they would be the ones more specifically to enforce that. We would certainly work with them, especially we found it.
But right now, the operators, when they do discharge both inside and outside the oil and gas fields, self-report to you. Isn't that right?
A spill, yes. Yeah. A deliberate dumping, that could be criminal violations.
Yeah. So if you could look at that incident report that I mentioned later, I would appreciate that. And so would the public. Thank you very much.
Have you completed your testimony or your cross, Ms. Manassi?
Yes.
Thank you. I'm just going to check in with the court reporter real quick. Do you need a 5-minute break before the commissioners cross Mr. Brinkard, or would you prefer to keep going?
I'm good. We can just plow through if everybody else is all right.
Okay. We will continue then. We will now allow the commissioners to cross Mr. Brancard if they have any questions for him. Commissioner Kessler, would you like to begin?
For the purposes of childcare, will you clarify if the meeting will end at 5 p.m., please?
It may go slightly over 5 p.m. Once the commissioners are completed with crossing Mr. Brancard, the meeting will conclude for the day and be picked up tomorrow. Commissioner Kessler?
Mr. Brancard, can you hear me?
Yes.
Can you please, you overviewed the process that you went through for informal public engagement. Can you just describe that in a little bit more detail? I believe that you said you circulated the draft rule, is that correct?
I'm sorry to interrupt, Commissioner Kessler. Could you please speak? My apologies.
Mr. Brancard, can you please review the public engagement process that you went through related to this rule? You mentioned an informal process. Can you discuss that in a little bit more detail?
Okay, so as I mentioned, we had sort of a group of folks who were involved informally with the other changes under House Bill 546, the enforcement rule that came before this commission. And during the process of that, I informed them that our next rule would be this rule change. And I handed out a draft to those folks and asked for any comments back from them before we officially came to the commission with an application. I went back to those groups and said, do you have any more comments? So it was a pretty informal process about this. And we also reached out to agencies such as the Environment Department.
Did you
And the state
receive any
engineer.
comments back based on your informal process? Did you receive any comments back?
We received some questions from representatives of the New Mexico Oil and Gas Association, and I believe that was it. And discussions with the Environment Department also about the proposed rules.
At that time, did the Environment Department express any concerns about the categorization of potable versus non-potable water?
We had specific discussions with it. Well, they wanted to know where we came up with that number and the definitions, and so we gave them information about that. You know, there was sort of a little bit of back and forth, but they didn't take any hard position about that rule at that point.
Okay, and I understand that at this point, the division has concurred in eliminating the distinction between non-potable and potable in favor of Sierra Club's suggestion. Is that correct?
That's correct, and we don't object to that either.
Okay, that's all my questions. Thank you.
Commissioner Engler, would you like to commence with questions?
Yeah, thank you. Bill, can you hear me?
I can hear you, Commissioner.
All right. I want to ask relative to a lot of this started with House Bill 546 and trying to address what was put in there. Part of that House bill was to, which really was part of, was to be able to generate what we did earlier was the penalty rules. Is that correct?
I'm sorry, I missed the last part of your question.
Okay, part of House Bill 546 was we generate penalty rules.
Yes. As it was finally passed, yes.
Yeah, and so we did that earlier this year as a means to be able to address that part of House Bill 546, correct?
Yes.
So when we talk about things like spills or discharges, in essence, what we tried to do, would you agree, for 546 was to try to create a means to reduce those events.
Yes, hopefully.
So, in earlier testimony, we were talking about spills and prevention versus monitoring. And would you agree that we took the first steps in trying to prevent spills by providing this penalty rule?
Yes, but again, the focus is on reporting the spills. I mean, that's one of the higher penalties actually in our penalty guidance, and so that's where the main disincentive would be, along with any kind of violation of a particular standard that we're called a particular practice that's in our regulations that resulted in a spill.
So from that first step, we've gone to this second step of what we're looking at today, which was again to address components of House Bill 546 with regards to both protecting the health, safety, environment, but really also to be able to come up with ways of reusing produced water. Is that correct?
Yes, there's basically two aspects to House Bill 546, largely, yes.
So what we're doing today is again, without the level of details, or as you mentioned, some further rulemaking, we're trying to set the stage so that we can do these things in the future.
Right. I mean, if we get into a specific rulemaking about produced water, we won't have to deal with these technical issues about compliance with language of the statute. That would be done with if they along with this rule proposal.
I think I'm gonna. That's what I want to clarify more than anything. And I guess one more, really, again, a clarification. This has been going on again repeatedly today. Again, the 546 in our rule is specifically designed for oil field, not the non-oil field events that come under the Water Quality Control Commission.
Yes, that's trying to draw that line very clearly as was put in House Bill 546.
So we really are addressing the requirements of House Bill 546.
That's my goal with this proposed rule.
Thank you.
Thank you, Dr. Engler. Mr. Brankard, thank you for taking the time today. I just have a handful of comments. For any sort of rulemaking, is any pre-public comment period required?
No, but it's not a bad idea.
So you think OCD took extra steps to engage in public feedback?
Yes, I mean, we could have just brought this application straight to the commission.
Thank you. Does OCD consider this really to be a first step?
Yes.
Do you believe that some of the numbers we get from this will help educate future rulemakings?
We certainly hope so, yes.
Does OCD have rules governing how produced water is cleaned up if it's spilled?
Yes, we have cleanup standards for spills, whether it's oil or produced water. They have to meet those standards.
There's been a lot of talk today using different words. The word spill has been used. The word discharge has been used. And illegal dumping has been used. First, can you describe to me what a spill is within kind of the regulatory framework of the OCD?
Well, our Rule 29 is dealing largely with what would be accidental spills or releases, and we try to use both words so we're covering everything.
So in general, a spill is something that is not intended.
Correct.
Thank you. So a discharge, can you describe what a discharge traditionally means within our rulemaking structure?
That's a word Environment Department tends to use more of. And so they have a discharge permit they require. So that's sort of any release of liquids that could cause a problem or not, or could potentially cause a problem.
Is a discharge something that's maybe more intentional or known ahead of time?
Well, yes, because you often have to get a permit for that.
So basically a spill is something that's not intended, and a discharge is something that's pre-known that may happen.
Or yes, or you have a good sense it might happen, yes.
Okay, can you now describe to me what an illegal dump is compared to a spill or a discharge?
That would be, a discharge is generally done in accordance with a permit. You get a discharge permit, like I said, from the Environment Department, or from us. We do issue discharge permits also under the Water Quality Act. Illegal dumping is something that's just completely out of the rules. There's no authorization for it, and it's intentional.
So if I were to say that a spill is something that happens that's not expected or intended, a discharge is something you get a permit for and it is expected to potentially happen, an illegal dump is something you very intentionally take an action to do that is illegal. Would that be accurate?
That's probably a decent simplified version of all of that, yes.
Thank you, Mr. Reichard. What would happen if, for example, we caught somebody illegally dumping? Do we have rules against that? You stated earlier it could be a criminal issue, not just a civil issue. Can you please describe the OCD framework around illegal dumping, please?
Right. I mean, we would investigate, but we would also, based on what we understood about the situation, we may want to refer that investigation to a local district attorney or the attorney general's office if we think there's the potential for a criminal violation there. And that criminal violation actually could be a criminal violation of the Oil and Gas Act, not just dumping, which is a more generic violation.
So you feel like that's already managed in some place within the Oil and Gas Act and within the OCD rules?
In the Oil and Gas Act talks specifically, that was a change that was made in House Bill 546, that the intentional actions remained criminal and the civil violations were no longer intentional. And so that's a distinction that's now in the Oil and Gas Act as a result of House Bill 546.
Thank you. Mr. Brinkard, does the OCD have authority to regulate any type of use outside of oil and gas operations?
I'm not aware of it, no. And we used to, but now we don't for produced water.
Thank you. Do you believe that the Produced Water Act actually makes off-field oil and gas use, so some sort of use not for oil and gas, more difficult than it was previous to this act?
I'm sorry, I missed the question.
Do you believe that the Produced Water Act makes it harder for produced water to be used outside of the oil and gas industry than before the Produced Water Act?
Well, I don't know if the Environment Department agrees with me, but I think it does, because it's much clearer where the jurisdiction is, and individuals can't play the agencies off each other. And so I think by having much clearer jurisdictions, it really should discourage that.
Thank you. Does the Oil Conservation Division's governing statute, the Oil and Gas Act, does it require that basically everything that the OCD does protect human health and the environment?
No. A lot of what the OCD does is regulation of the industry. and it's designed to prevent waste and protect correlative rights. That's the standard for a lot of what the agency does. But when the agency deals with wastes, produced water, that's then the standard of protect human health and the environment comes into effect.
Thank you. Does the OCD have jurisdiction to regulate worker safety?
No.
Does the OCD have jurisdiction to regulate things such as the design of trucks that may transport oil and gas material?
No.
Does the OCD, do you believe the OCD has jurisdiction to ban the use of fresh water? I think you touched on this a little bit earlier.
Yeah, I think that's something that we need to be clear about before, if we're going to regulate, whether we have that authority or not. And I'm not sure we're clear about that right now.
Okay, thank you. Would the OCD be opposed to changing the, the language that refers to the appropriate district office to approved by the division?
No, we would not be opposed to that.
All right, well, that completes my questions, Mr. Brinkard. Oh, Commissioner Kessler has one follow-up question.
Mr. Brinkard, you discussed how this was going to be one of potentially a series of rulemakings related to House Bill 546, correct?
Well, related to produced water, yes.
Correct.
Yes.
Related to produced water, in the event that the division moves forward with additional rulemakings that have substantive standards, do you anticipate additional scientific review and community input?
Yes to both of those. I mean, we would certainly reach out and have a more robust stakeholder process and our public review process prior to any formal application. And we would certainly need to have good science behind what we're doing.
Okay, thank you.
Mr. Brinkard, Mr. Lozano has a question for you. Commission Counsel. Sorry, Bill.
Sorry,
One more.
Bill. Can you hear me, sir?
I can, yes.
I'm just curious. So, in looking at all of the proposed changes that the other parties have put together, are there any specifically that give you, say, heartburn about whether it was, if the commission were to adopt it, it would be a notice issue with regard to this rulemaking?
Yeah, I think I mentioned a few of them already. The requirement for either a permit or registration, the prohibition against the use of fresh water, and I think there were some other standards that were totally new in there about worker training, et cetera. Those seem to be questionable whether they are inside the scope of the notice that was pretty specific about what the changes were that were being proposed. So that's our concern about whether those proposed changes are outside the scope.
Thank you, sir.
Commissioner Kessler, Commissioner Engler, do you have any follow-up questions for Mr. Brinkard?
No, I do not.
Okay.
I would like to ask one question on redirect.
Go ahead.
Would the OCD be opposed to a change that said that activities such as dust control on well pads or roads was not allowed?
I don't think we would be opposed to that.
Thank you, Mr. Brinkard. So that will conclude today's portion of this hearing. We will call for a recess until tomorrow morning. Beginning the meeting tomorrow morning, we will review any requests to make a public comment today, and we'll allow those individuals who provided timely notice to make a public comment tomorrow morning. We will also, again, call people who were not available to speak today to provide public comment. Following public comment, we will proceed with the hearing and move forward.
A point of clarification, since we did not see a detailed agenda of this hearing, is there going to be an opportunity for a closing statement from the parties to this matter?
Yes, there will, following testimony.
Okay, thank you.
Madam Chair, this is Douglas Micklejohn. What time will the hearing start tomorrow morning?
9 a.m.
Thank you.
Any other questions from the parties? All right, well, it is 5:15 on Thursday, July 30th, and we will recess this hearing until 9 a.m. tomorrow. Have a good evening, everybody. Thank you.
Thank you.